Supplemental list, old matter, item number 1.
Your Lordship, item number 1, no instructions for liberty.
All right. No instructions dismissed.
Lordship, item number 1, item number want to liberty may be given to withdraw this writ of appeal because your last occasion, your
Because
Lordship.
you're appearing the same matter,
I'm appearing on behalf of Mr. B.K. Parida.
then who is he for?
I am for the appellant. I am for the appellant.
What is
Want to
who
withdraw
is for?
this
I'm from the appellant too.
Sir, you better decide who's appearing for the appellant.
This matter was Mr. Mukherjee was engaged in this case in this matter.
Anyway,
as a senior
either way, he
counsel.
wants to withdraw. He says
I am
no
on the
instructions.
record.
All right.
No, I am on the record. Yesterday night.
Okay. While one Mr. A.K. Behera claims he's appearing for the appellant and seeks to withdraw, one Mr. B.K. Parida appears for the appellant. It says that he has no instructions. Either way, for either reason, the appeal is dismissed. Right. Interim order of any is vacated. Brought it.
Supplemental list, item number 2.
No instruction.
No instructions dismissed. All right.
I am appearing for the Mott matters opposite party number 1.
Both matters.
Supplemental list, item number 3.
I may plead your Lordship. I am
Yes.
on virtual mode.
Yes.
But you can look at your Lordship's order dated 19/9/2020.
Yes.
19/9.
Yes.
Before that, your Lordship's order, see the order, your Lordship 4/7/2020.
Yes. What of it, Mr. Mahapatra?
My lord, the affidavit on the basis of instruction, that's why before my lord senior start submission, after some only 3 to 4 day time may be granted.
Mr. Mahapatra seeks some more time to file
In fact,
affidavit
the school is
It'd be
closed
positively
in
filed
2016.
on or before 2nd January 2023. It's on 9th January.
Item number 4.
My lord, I have already filed the IF for impletion of party. So let the IF be tagged with the writ petition.
What about, sir?
Matter about kneeling down of 6 boys and girls before the police station, my lord.
Please, what is the IA for, sir?
IF for impletion of the party is namely Sri Alok Ranjan Rai, who was the IIC at that time.
Where is it? It's not come on record.
It's not.
My lord, my responsible submission is that these are the matters to be decided by the Human Rights Commission.
Correct. No, but anyway, this has been pending here for almost 9 years now.
And my
He
lord,
wanted to impede the concerned police persons. He's not done that. Still,
yes, I have already filed the
it's not there, sir.
IA, my lord.
It does not come on record.
I number 15623 of 2020.
You will have to make sure it comes on record. The IA stated have been filed, but the petitioner is not on record. Just on 9 January.
Item number 5.
Late please, your lordship. Well, the pivotal point actually in this case, if your lordship, the genealogy is there before your lordship, the family.
Last time a submission was made that there's some Supreme Court judgment
Yes, madam.
because of which the single judge's judgment is unsustainable in law.
But
That's
here
what we seem to have noted.
legal point is that the daughter was born before 1956. The question arose, number one, whether the father has died prior.
She's a married daughter or an unmarried daughter?
No, not married. At the time, she was not married. Married after 1956. She was in possession of the properties when the 56 Act came into force. And it was she was in physical possession of the property in view of Section 14. You know that it matures into title. But the limited interest that a widow gets as per the 1937 Act, that has been extended in Article 43 of the Hindu law, Mullah Hindu law. If you also looks at that, it also gives the benefit corresponding to the correspondence with the widow. The daughter also gets, unmarried daughter, gets the benefit also that limited interest will get matured after the 56 Act came to force. This is first point. Second, is on the basis of a death certificate, which was obtained in 1994. The death they claim, they have not indicated at the time when they filed the objection before the consultation authorities when the father of the petitioner died. But they say it is prior to 1956 without mentioning any date. But subsequently in 94, they made an application for a death certificate. 94, as your lordship knows, excuse me, after the expiry of the period, more than 1 year after the central statute and the state law, that if an application is to be filed to obtain a death certificate, an inquiry has to be conducted. But here the question is the presumption of correctness doesn't attach to that. Had it been within 1 month or within 1 year at best, the presumption of correctness would have attached to the document. Now, the local inquiry that was made by the CO, his report is there. He says the death is after 1956. But solely basing on this certificate, which was obtained in 1994. So the registry entry is 1990, that the death has happened in 1947. The court has said the father died in 1947, prior to 1956. Though the local inquiry with the CO itself shows that it is after 1956. So these are the two main points which I want to canvass with your lordship in this case, that the commissioner has taken note of that. Commissioner has given a relief in my favor, saying that the record is absolutely correct. The appellate authority reversed by the CO's order. Commissioner reversed it. When the Honorable Singh's High Court Malad, they say that no, after she died, after basing on the same registered document, that the death certificate, the Honorable High Court said that since the day after 1956, the daughter doesn't get a right to the property itself. That's the sole point, in fact. There, I think, if Lordship looks at Article 43 of the Hindu law, I can give you Lordship the copy I have got. This is an order of succession among shopinders. The clause, Article 43, is the 20th edition, Volume 1 of the Mullah Hindu Law. Let's return to the third page, limited estate. 5.3.
Yes.
5 comes daughter, it is 3. Excuse me. The daughter takes a limited interest in the estate of her father corresponding to the widow's estate. And on her death, the estate passes not to her heir, but to the next succession. That's a subsequent succession to that effect. So even assuming the death is prior to 1956, still daughter gets a right, which gets matured as per Section 14 Marad. So that is one of the points. Second point is, if Lordship looks at the decision of the Karnataka, that is Subbarau's case, that Karnataka decision which says that the certificate which has been obtained more after the statutory period, the evidentiary value thereof, Marad. Is a change of date of birth as per the service record. That was the subject matter there. But paragraph 6, if Lordship looks at. Page 804. Page 804, Marad. Equally so, I do not see any reason how the petitioner could ask for a writ of certiorari to quash the decision taken by the corporation to retire him from service on attaining the age of superannuation. On the basis of the date of birth entered into the service register, the contention urged for the petitioner that the birth extract produced by him was binding on the corporation since it was based on order made by the magistrate cannot be accepted. It is an accepted principle that an entry in the register of birth is not a conclusive evidence of the disputed date of birth. All made pursuant to the direction of the magistrate on Section 13.3 of the Act. 13.3 says, any birth of death which has not been registered within 1 year of its occurrence shall be registered only on an order made by the magistrate of the first class or of a president magistrate after verifying the correctness of the birth or death on the payment of the prescribed fee. The policy of the law embodied in the section, as it appears to me, is to avoid manipulation of the entries relating to date of birth and deaths. Such entries shall be made immediately after the occurrence. Precautions should be taken while making delivery. The law says that an entry which has not been made within 1 year of its occurrence cannot be made without an order of the magistrate. 13.3 of that is just a constraint of the registration. It is not provision. It is not a provision where an aggrieved party could get an adjudication of a dispute of date of birth. Order of magistrate binds only the registered, not the others. The entry made by the registered pursuant to the order of the magistrate cannot carry a higher probative value. This proof must be necessary depending on the facts and circumstances of the case. It doesn't have a presumptive value of correctness, though the Honorable High Court and the Appellate Court, Revisional Court didn't accept. Held that the certificate itself, the death is prior to 1956. And that is how actually they held that the daughter doesn't get a right to the property. And the Revisional Court rather, they dealt with the matter with regard to this clause 43. Article 43 of the Hindu law, but the Honorable High Court has not taken note of that, nor the Appellate Court, which reversed the trial court finding.
All right. Yes, please.
Met Lordship. And Lordship, kindly see the order of the Honorable Single Judge, my Lord. That is page 23, internal page 2, my Lord. With regard to the genealogy, my Lord.
Correct.
Yes, my Lord. My Lord, the Bhagavata Naik has two sons, that's Raghu and Lakshman. The question is Lakshman, the deceased father of the opposite party. That is died on 18/1/47. And then, my Lord, his daughter is Nisamani, OP1. That is, my Lord, what my senior might say that question of death of Lakshman, my Lord. To that effect, that is confirmed by the Honorable High Court. That is in writ petition, that is annexure. Two times that the writ petition has dismissed to that effect, challenging the pass of the registration of the date of death, that is 18/1/47. They have challenged before this Honorable Court. That has been rejected. Then we recall that orders. That also rejected. Again, they filed second writ petition. That also rejected. That is annexure 14 and 15, Your Lordship, in writ applications. Here, the question is whether the single judge, the pass order with the point of law or not. What is illegality committed by the Honorable Single Judge, my Lord? I may be permitted to read that person's ordering person, my Lord. Page 27, internal page 6, my Lord.
Yes.
Paragraph 8. Undisputedly, the property in question was the ancestral joint family property of petitioner's father, Raghu and opposite party number 1's father, Lakshman Naik. There is also no dispute that Lakshman Naik died in the year 1947 in jointness. The Constitution Commissioner in his revisional order also accepted the position that Lakshman died in 1947. Under no point of time, it has been claimed by party number 1 that wife of Lakshman Naik was alive at the time of his death. On the contrary, she claimed that her father died, leaving her as the only heir of the successor. Therefore, it was not open to the Commission or Consolation to make out a third case holding that widow of Lakshmana acquired limited interest over the disputed land left by her husband. The Commissioner has failed to take note of the plea advanced by opposite party number 1 throughout the proceeding that her father had died, leaving behind her as the only legal heir and successor. Had the wife of Lakshman Naik been alive at the time of his death, OP number 1 would definitely have taken the plea to that effect. Keeping in view the pleas raised by the parties before the Consolation Forum, it must therefore be held that Lakshmana died in 1947 in jointness with his brother Raghu, leaving his only daughter Nisamani, that is opposite party number 1. Therefore, opposite party number 1 being a daughter whose father died prior to Hindu succession in 1956 came into force, could not be succeed to her father's interest in joint family property.
What do you say to this Mullah's Hindu law, para 43? Was daughters mentioned?
Here my question, whether the daughters at the prevailing act at that time that has been succeed or to the reverse to the branch of the Lakshman at that time, my lord.
So what do you have to say to this commentary, which he has relied on, para 43
That
of the
has-
Hindu law commentary?
I'm sorry.
That is limited estate, my lord. The daughter takes a limited interest in the estate of his father corresponding to the
Where are you
widow's
reading, sir?
my lord. That is my lord. Yes. Her father corresponding to the widow's estate.
So what do you say to this? So even prior to 1947,
My lord.
she still has a limited interest.
No,
That's what this commentary says, sir.
here my question, that is my I may permit it. The revisional court had make out third case that is the woman's right to property act. At the time of death is that is the widow is pre-act widow of the Lakman, my lord. So that the question doesn't arise at that time. Daughters had no right at that. If it had been died after the death of his Lakmana, then matter would have differed, my lord. That is the main point. You also can see. At that time, the widow, pre-act widow.
This is all pre-act, sir. This commentary is about pre-act only.
The daughter takes a limited interest in the estate of her father corresponding to the widow's estate, my lord.
Correct.
Yes, my lord.
This is all pre-act, sir.
And that is, my lord, that is the widow's estate. That time widows were not there, my lord. Here claim is from the father's property. His claim is father's. Newly his claim in the revisional court, the property comes from his mother, my lord. He demands from mother's side, my lord. My case is that the mother had died prior to his father, my lord. So there is no question of succession. That is the main point, my lord. And to that effect, the revisional court has made out a third case, my lord. That is the point, my lordship. And that's why the Lord Single Judge rightly held that if, my lord, had the wife of Lakman had been alive at the time of death, so matter would have different, my lord. All right. And also you listen, my latest judgment, my lord, senior also know that 20, my lord, that is the that whether that
Where is the judgment, sir?
yes, my lord, I'm giving that. Yes. That is yellow sheet.
Have you given him a copy?
Sir, I'm sorry, sir. Sir,
What is this way of arguing, sir?
no, sorry.
ठीक है.
No, no. Sir, the-
Place करो sir. Place करो. Let him play, sir.
sir, the-
Sir, अपन पे था उस वक्त.
yes, sir.
Which paragraph?
My lord. That is, my lord, page 607, paragraph 58. What is the effect of the with respect to the Operation Amendment Act 2005, it was observed that the same is prospective in nature and not retrospective. Those. Neither in the 1956 Act nor the 2005 Act seeks to reopen vesting of a right where succession had already been taken place. The operation of the said statute is no doubt prospective in nature. The High Court might have committed a mistake in opening that operation of Section 3 of 2005 Act is retrospective in character. But for the reason of aforementioned, it does not make any difference. What should have been held that although it is not retrospective in nature, in application is prospective. So here, my lord, question whether the father died in 1947, whether the daughter's right to inherit the property or not, my lord. To that effect, the Honorable Single Judge rightly held that at that time, prevailing law is there. So it, in view of the latest judgment, it cannot be effect from that and retrospective effect.
So it doesn't have any application with due respect to him. But this relates to effect of 2005 amendment.
Yes.
I am not basing on that. My question is at the time of 56 Act, it came into force.
Correct. Whatever the vested rights
What was the
you had.
effect? Section 14 is there.
No, but he says there was no widow. He says you could have got it only through the widow.
But
Since she
here
did not predecess the.
But if your lordship looks at that clause 3, but here actually death of widow is not there in evidence. No evidence is there.
No, but she did not survive her
Yes,
husband.
did not survive. But still,
So there was no widow at all then.
But if
Through
your
whom she
lordship
could have
looks at,
inherited.
even if there is no widow, that clause, the 5.3,
Let's see that again.
if your lordship reads that language, my lord. The daughter takes limited interest in the estate of her father corresponding to the widow's estate.
Correct. If there's no widow at all, then what happens?
But the daughter automatically gets that limited interest.
That's not how this reads. That's not how this reads. There's a logic, sir. There is a logic.
Right.
That is
But,
only,
Correct.
if your
that is
lordship-
only related to widow's interest.
Yes.
When the daughter claims inheritance
So
from
when
the
the widow
widow's
dies,
interest,
she gets
correct,
that.
then that
Correct.
is applicable.
Correct.
And another thing I want to point out,
No,
your
just
lordship.
one thing,
Okay,
sir.
I'm sorry.
So kindly have a look at page 53 of the writ application, my lord.
All right.
Because I took two grounds, my lord, with your lordship. One is that Hindu law. Page 53 of the writ application, Annexure 8 is a part of Annexure 8.
Written statement. Annexure 8.
Annexure 8 is a part of Annexure 8.
Okay. This is an order.
Yes.
Judgment dated 3/2/92.
Yes, my lord, right. If lordship looks at today, that is on 3/2/2022, I conducted local inquiry in presence of both the party and gentlemen of the hamlet, village, sitting at Mahila Padia, located on the LR plot number 326. The hamlet villages, Puran gave the writing one application stating that the history behind the dispute between the parties, which I received and enclosed in this record. Then the subsequently next paragraph. Lakshmana Naik, the father of opposite party Nisamani Naik, has expired after 2 to 3 years of the Daleighai, that is 1956, as it is collected from the villagers and mentioned in my spot inquiry report. Further, Lakshmana was separated much earlier to the death of from Kishan and Mills. But he died after 1956. That was a local inquiry by the CO himself. Now, that is the specific case throughout the stand. He died after 1956. For the first time, 94, they obtained a certificate and filed it. Therefore, I say whether the 94 document can prevail over this local inquiry that was conducted by the CO himself, the court himself, because they used to make local inquiry at the time of adjudication of disputes. And he has conclusively held that since he died after 1956, daughter automatically gets right to the property. This has been rebutted by obtaining a copy after this. This is 92. To dislodge this finding of the local inquiry.
The problem in these kind of proceedings is how do you go behind an official document? If there's a death certificate issued by an authority,
yes,
unless it's a civil court's decree where all this can be tested, whether this is actually
yes, they are specific. The objection that was filed.
No, mere objection. Just in a proceeding of this nature is quasi-judicial by and large.
Quasi-judicial.
So once you produce an official death certificate, how does the authority go behind that?
That is what I wanted to submit just to assist your lordship. Section 35 of the Evidence Act, my lordship knows it very well.
Presumption of
relevancy of entry in public record made in performance of duty and entry in any public or other official book, register or record stating a fact in issue or relevant fact and made by a public servant in the discharge of his official duty or by any other person in performance of a duty, especially enjoined by the law of the country in which such book, registered or electronic record is kept, is itself a relevant fact. 35.
No, it's only about a presumption.
No, the probative value. Also, there are decisions so far as death certificate, so far as birth certificate.
Sir, if it is obtained within 1 month or within 1 year,
there is no.
Then that's what. Yes, that is the decision I've cited. The reason being, the presumption.
No, this
can
is
be
the Karnataka High Court judgment.
Yes, that itself, a presumption could have been attached if it would have been obtained within 1 month. Report would have been there in 1 month and obtained within 1 year. If beyond that,
No, but by merely saying that it is beyond 1 year,
yes,
can you falsify the certificate is the question.
I'm not falsifying. It has to be corroborated. It has to be corroborated.
The failure to corroborate or whatever, does it mean that this case has to be completely rejected?
No, I don't want.
Is the onus not on you? No, the point is you are questioning the correctness of that certificate.
Right.
The onus is on you to show it is incorrect.
Sir, local inquiry, oral
It can't be a
evidence.
negative inference saying that because the certificate is not corroborated, please discard it.
So what I beg to submit for Lordship is that 92 evidences prior to this document. Am I clear, my lord? Till 92, the evidence that was collected and evidence has been laid by both the parties. All villagers have stated that he died after 1956. Suddenly he applies in 1994 and gets a document to negative this.
No, but we can't find fault with the quasi-judicial authority or single judge for that matter for relying on an official document.
But they are actually the presumption of this document, with due respect, my lord.
No, it's a rebuttable. Let's assume it's rebuttable presumption, but you have to rebut it by leading evidence.
Well,
you have to produce material to show the contrary.
So I respect your lordship's view, my lord.
Wow.
But this was actually relied upon in appeal, not in.
Wherever, sir. The question is, it's an official document.
My lord, your lordship is saying why my learned friend is not showing that portion of the impugned judgment. In the impugned judgment that has been dealt with, he has challenged this certificate in another proceeding that was dismissed.
No.
And yes, that's page 4 of the impugned order.
So with due respect, can I just submit one thing, my lord?
Yes.
With due respect to my lord's friend, my lord, that was challenged that such a document, such a certificate could not have been issued. But the court said that they have the right to issue. So that's a different matter.
In any case, that certificate has been confirmed by the
Honorable High Court. Another certificate has been filed. If you also say rebuttal evidence, another certificate was also filed in this case. That was of the year 1956. The Honorable Court said that since in 94, one document has been filed of death in 1947, another document could not have been obtained from 1956. A rebuttal evidence was given, not that it was not given. That was rejected because only 94 document has been obtained. They also applied and got it. The respondent, the petitioner here, they also, if you also kindly see that finding, they have also obtained a certificate which is of 1956.
Let's read that what single judge says.
impugned judgment page.
So kindly look at the judgment, appellate court judgment. Sir, it starts from page
25 of the writ appeal.
25. So 25. Sorry.
During the pendency of the objection cases before the confirmation, the date of death of Lakshmana Naik having been disputed by the parties, the petitioner initiated one. So what my learned senior is submitting, that is already discussed and decided against him in the impugned judgment.
Yeah, that's exactly it. Could not have been discarded. What is that saying here? Sir, at page 772. See the certificate also.
This come to page 25.
Sorry.
Mm-hmm. Mm. 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 Come to page 25, sir. Writ appeal paper book.
Read appeal, Lord. Sir.
Bottom.
Page 25.
During the pendency of the objection cases.
Yes, sir.
Please
During
read
the
that, sir.
pendency of the objection case before the constituted officer, the day has been disputed with the parties, the petitioner initiated this case also with the executive magistrate Jagat Singhpur. 13th of the birth and death registration act for issue of death certificate in favor of Lakshman. The present opposite partner also appeared in the miscase, and executive officer also got matter inquired through Tahsildar and allowed the miscase contest holding that Lakshmana died in 18/1/1947. Accordingly, director registered birth and death to register the date of Lakshmana accordingly and issue death certificate. Challenging the order of the executive magistrate passed in so that Lakshmana opposite party filed WPC before the court, and this writ application was dismissed on merit by the order dated 5/9/96. As subsequent miscase filed for recalling the said dismissal order also dismissed again. Cause of action of the opposite party filed a second writ in OJC so which was also dismissed by 14/3/97. Considering the order of the
So how many
constituted
repetitions, sir? Oh, got 2 repetitions already dismissed
but that was
for the
because
same thing. That's what the single judge notes. You can't have so many shots.
but in fact subsequently they have also applied in the certificate
No, that is separate.
that was also
Your
discarded.
attempts at challenging the death certificate of 1947 on 2 occasions failed. We pass the detailed order. Dismissed. Dismissed. Right.
Item number 6.
My lord, today appearing complaint, my lord, put on
in item 6, my lordship, Mr. Rautray was appearing. Now, the before transfer from our office, the appearance of Mr. Rautray may kindly be ignored.
It is stated that Mr. Buddhadev Rautray is no longer handling is no longer appearing for the appellant. Who's appearing now?
my lord. I am appearing on Wakalatnam. Mr. Manaschan and associates.
Mr. Manas Chand and associates are now appearing for the appellant, and their Vakalatnama is taken into account. Yes.
My lord, kindly call it any other day, my lord. Yesterday night,
Is there a stay? Some exam, is it? This is BDS final year exam of 2012.
my lord.
How does it survive now, sir?
My lord, I pray, my lord, give me a last chance. Yesterday
No. How
evening,
does it
I
do? Explain to us.
counter not filed also.
I think my lord, she has already passed since 2013.
Ah.
I think in the meanwhile, 9 years, more than 9 years, must
Ah.
have served somewhere.
No, what's the point in deciding?
Point
this
involved
issue
is
now?
that, my lord, a
What
particular
marks
answer
must have
script,
got in 2 papers in
Was
2012?
particular answer script was valued.
Ah.
Then the petition have come up that yes, I have not been given a mark, so it should be valued by 2 examiners. The question is that one answer script, university didn't have that facilities. One examination is over. But here in this case, they refer to a BDS regulation, said that yes, in case of contingency, that can two examination can value it. The honorable court considered this aspect and also considered the fact that he has already passed the examination in 2013.
Oh,
That is what they concluded. My lords directed to get the record whether this paper is available. We didn't find with much difficulty. We tried to find out. In the meanwhile, 5 control of examination already.
because last time also I remember they told us that the paper is not
traceable.
Yes.
My lord.
So called academic, purely academic. You say the issue before the, yeah, the issue before the learned single judge concerned the evaluation, the prayer of the appellant for re-evaluation of her answer scripts in 2 papers. That is the orthodontics paper B and the oral maxillofacial surgery papers A and B of the BDS final year exam 2012. Paragraph. It was noted in the impugned order 88 July 2015 of the learned single judge that in the subsequent year, the appellant had appeared in the examination and passed the same and received the certificate. Full stop. In those circumstances, it was observed, open quotation, therefore, any action now taken will amount to futile exercise and would be purely an academic one. Full stop, unquote. Paragraph. Moreover, it appears that the answer scripts were not even preserved. Full stop. We are now in 2022, whereas the exam was of 2012. Full stop. With the appellant already having passed the examination in the subsequent year and also having obtained the certificate, the issue has indeed become academic and does not call for interference at this stage. The appeal is accordingly dismissed.
My lord, I beg one thing, my lord. Kindly taken up tomorrow, so my senior may.
No, sir.
Item number 7.
My lord, let it.
All right. Yes.
My lord,
yes.
Passover
Who's at 7, please?
My lord, I pray for Passover intimating.
No, sorry. Yes.
Yesterday evening,
It's all right, sir. We cannot help it. Yes.
My lord, humble request, my lord.
Fine, sir. Fine. Not a problem. Yes.
Item 7.
Yes.
May I please, your lordship?
Yes.
My lord, petitioner belongs to scheduled tribe, my lord.
Yes.
And in this case, principle of res judicata is not applicable because of both the proceedings are different cause of action.
Yes.
Lordship, kindly see.
Yes.
Page 24, paragraph 6 of the impugned order.
Yes.
This court, therefore, finds the following question required to be decided. Have you got it? Paragraph 6 of the impugned order.
Yes.
Whether the second successive petition involving the same parties involving the impugned orders after dropping of the first round litigation between the parties initiated under provision of Regulation 2 and 56 is maintained or not. My lord, coming to the question framed herein above and looking to the observation already made herein above, this court finds that petition has a clear case all through the involving transaction in the first round litigation. The opposite party initiated proceeding regulation case 144 of 1997 following the provision under Regulation 2. You'll also kindly, just a minute, you'll also kindly see page 27, Annex 3. You'll also see 144. That relates to plot number 385. You'll kindly note it. Thereafter, my lord, admittedly, the said proceeding was dropped after considering the dispute involved therein and on merit involved. This being the admitted position and there being no material available that any challenge was made by the opposite party 6 and 7 involving the orders.
Opposite party?
Right.
You were to file an affidavit. What happened?
Today I have filed affidavit.
Where is that?
So today I have filed it.
Involve the same property is not the same property. My property is the plot was 370 and 380. That is reflected in the first.
What day did you file the affidavit, sir?
Today I have filed it.
Where is it, sir? You have got a copy of the affidavit?
No.
You don't give copies to other sides, sir.
Today I have filed it. Just I brought the copy for him.
How did you file it without serving a copy? In our High Court, you can file without serving copies, is it?
First copy has to be served.
Where is the filing memo? Show us the file.
You have filed or are you going to file?
Today I have filed the.
How is the filing without serving copies? How do they accept the filing? How do they accept without copies?
No. Actually, what we used to do, we file and then serve copy on the state. That is filing memo is there.
No, I'm saying it's not been served on the counsel for the appellant.
He must have filed it in
to the
office.
opposite.
So it is not
hiding this
attached.
case
The
for more than
respondent
50
states that
years.
he has filed the affidavit
He's-
today
More than 50 years he's hiding this case.
and has served a copy on counsel to the appellant today in court. The affidavit be brought in record. List on
Tomorrow can.
16 January.
Item number 8.
My lord, so far as item 8 is concerned, I may be permitted to take some time for filing a current status. I have discussed with the Tahsildar today.
All right.
This is yes.
The monthly learned counsel for the state wants some time to ascertain the current status and file an affidavit.
Interim order to continue, my lord. It is there.
Where is interim order, madam? Which date was it passed?
6th February 2019.
Interim order to continue. List on 16 January.
Item number 9.
None appears.
Item number 10.
Letter is not given to us.
It's a writ appeal, sir. Not a problem. You just argue what is the matter about. Tell us.
My lord, counter is not given to us.
Kindly tell us what the appeal is, sir. This is an appeal. Counter may not be important. Tell us what this writ appeal is about.
On behalf of Mr. SP Mahanti.
What is the writ appeal about, sir? Kindly tell us what the issue involved is.
My lord.
Sir, I'm appealing in the case for the optic partner 1 and 2. Relief claim against the optic partner 3.
What is the matter about? Tell us, sir.
The matter, sir, writ application, the petition of the appellant challenge the order of the single judge and for family pensions. They filed the writ application for reading the family pension under the EPF scheme 971. That is the single judge have to clarify in the order that is space 11 of the appeal. I mean virtual product.
Page
The
11.
deceased employee, husband of the petition, had not opted for family pension scheme 1971 as per the provisions of the said scheme with effect on 1/4/1971. As such, no contribution was and deposited in the employee's family pension scheme 1971 during the period of the employment. After the completion of 60 years of the age, that is on 31/7/1991, deceased employees the husband but ceased to be a member of EPF scheme 1952 with effect from the said data. Both the employees share and employees shares of provident fund contribution.
How can she get it? Yeah. Correct.
Contribution 23.
All right. The challenge in the present appeal is to an order 9 September 2019 passed by the learned single judge, dismissing the appellant's writ petition civil number 15816 of 2019. It's of the issue raised in the writ petition. No, the writ petition had been filed for quashing of an order dated 14th May 2019, passed by the Regional Provident Fund Commissioner. Dismissing the claim of the petitioner. Paragraph. In fact, it was the second round of litigation before the learned single judge. Full stop. Earlier, the appellant had filed a writ petition, civil number 24668 of 2017, which came to be disposed of by the learned single judge on 5th December 2017, with a direction to the managing director, Orissa State Road Transport Corporation, Bhubaneswar, bracket OSR, bracket, to dispose of the representation filed with the appellant. Full stop. The said representation dated 31st January 2018 was disposed of by the Regional Provident Fund Commissioner Employees Provident Fund Organization by the 14th May 2019, noting that the husband of the appellant had retired from service of the OSRTC on 18th May 1992 and expired on 15th August 1992 prior to implementation of the Employees Pension Scheme 1995. Full stop. As far as the earlier Family Pension Scheme of 1971, which was in force with effect from 1st April 1971, since the husband of the appellant had not opted for it, no contribution was diverted and deposited in the said scheme during the period of his employment. Full stop. As far as the EPF scheme was concerned, both the employee's share and employer's share of the PF contribution were settled on 23rd June 1992. Full stop. Paragraph. The above factual basis was noted by the learned single judge in the impugned order. Full stop. It has been noted further that, open quotation, neither any document nor any evidence has been produced by the petitioner's counsel or by the petitioner herself, nor a pleading is available on the record itself, unquote, to show that the husband of the appellant had opted for the Family Pension Scheme 1971 during the period of his employment. Full stop. This being a purely factual matter and with no material to the contrary being placed before either the RPF or the learned single judge, or even this court, this court is unable to come to a different conclusion from that reached by the learned single judge. No grounds have been made out for interference with the appeal order of the learned single judge. The appeal is accordingly dismissed.
Appearance में recorded मतलब up to 1 and 2.
All right.
Item number 11.
May I please, Your Lordship?
Yes, please.
In item 11,
yes,
there's an IE for condemnation of delay. There's a delay of 5 months. But if Your Lordship will kindly look into the order of Honorable Single Judge at page number 53.
Yes.
I'll just place that order, Your Lordship. The order of 1st of May 2019.
Yes.
Heard Mr. So-and-so, the second paragraph, for the self-same relief, the petitioner had filed representation. This court-wide order dated 31/7/2012, passed in WPC number 13690/2012, directed the opposite parties to consider the representation. On consideration, the representation of the petitioner was rejected. While order dated 13th of September 2012, the same was not being challenged in due time. Subsequently, WPC number 21345 of 2018 was filed, seeking self-same relief. This court, on 27th of March 2019, on the request made by learned counsel for the petitioner, permitted the petitioner to withdraw this application with liberty to file a better application. Hence, this application. The petitioner has filed his application claiming pensionary benefits available to the counterparts who are working in the government schools and other aided schools in the state of Orissa. Mr. D. Bharadwaj, the understanding counsel for School and Mass Education Department, submits that for the self-same relief, the petitioner had earlier approved this court by filing WPC number 13690/2012, which was disposed of by order dated 31st September 2012, directing the opposite party state to consider the grievance of the petitioner, and the same was rejected on 30th 2012. Therefore, this
so what were you doing for 6 years?
That is the sole question, Your Lordship. The question for consideration is, have I, in my personal capacity, filed WPC number 13690/2012? That is the sole question.
No, but even if you had not filed 2012, then you anyway came to the court only in 2019.
My lordship may kindly consider, I have claimed in the writ application for my right of pension that is akin to the government teachers.
When did you retire?
I have retired in the month of 2019, your lordship. 2019.
No, when?
The exact date, your lordship. On 30/3/2019, your lordship. 30th of March.
Did you file a review petition? So you did not file the earlier writ petition?
No, your lordship.
Then you file a review petition. That's the whole basis of the impugned order is that you had earlier filed a writ petition which was
that I have never filed. I have never filed. Even I have enclosed that.
You file a review petition, then it's obviously an error on the face of the record.
Then you should give me liberty.
Yeah.
What has
Counsel for
happened?
the appellant contends that the appellant had never filed an earlier writ petition, which the earlier writ petition civil 13690 of 2012, which was disposed of by the learned single judge on 31st July 2012. Substance, this forms the very basis of the impugned order of the learned single judge. The counsel for the appellant seeks leave to withdraw the present appeal with liberty to revision before the learned single judge in accordance with law. This post off is withdrawn with liberty.
I should kindly observe that the limitation period may kindly be condoned because in the
that obviously we don't have to say that. When you explain in your review petition, you will say that this writ appeal is pending. Yes.
Grateful, Your Lordship.
Item number 12.
Well, no instruction.
Counsel for the appellant says yes, no instructions, dismissed.
Item number 13.
Let's not turn to page 46, annexed to with the judgment. That relying that judgment of Arlok Mishra case, the Honorable Single Judge are directed to grant. And that has been stayed before the Honorable Apex Court.
When is this coming up, you said?
That I have given that continuation order, my lord, no date has been fixed. Lordship has just fixed it 12 chapter.
No, but how much? This batch is huge.
Your Lordship, I have given that second order, Your Lordship, my Lord's order, second order. Your Lordship fixed it to 12 weeks after.
I know, but now this batch must be growing, no?
Perhaps it will come up after December because Supreme matter is fixed to before Honorable Apex Court in December. Let it come after this. And there is a delay of 42 days. I have not filed a limitation. I will file the delay limit condemnation delay petition.
When you cure the defects, counsel for the appellant says this, he'll cure the defect pointed out within 1 week. List thereafter.
Item number 14.
May I please, Your Lordship. Here I have assailed the order of Honorable Single Judge in allowing the writ application of the present respondent, my lord.
You have not filed certified copy.
It's not, I will file, my lord. I will file, my lord.
Counsel for the appellant takes 1 week's time to cure the defect pointed out. List thereafter.
Obligement.
Item number 15.
Your Lordship, I am appearing for the appellant on behalf of Mr. A. Rother.
Yeah. Dismissed as withdrawn. Taken the memo on record.
Oblige, Your Lordship.
Withdraw. Press admission item 16.
Yes, my lord. The villagers have made representation before the collector for the substandard construction work carried in respect of CC Road and
which matter, sir? Which matter? Which matter are you appearing?
16, my lord.
Review petition 29.
No, my lord. PIL.
Sir, item 16, which has been called is review petition 29 of 2009.
Sorry, my lord. I'm sorry, my lord.
He's saying 15 perhaps.
No, that's been withdrawn.
That is withdrawn.
Item 16.
None appears dismissed.
Item number 17. Supplementary list item 17.
Is a representation. There's no proof of.
Or perhaps he was mentioning item 17 because that pertains to Millard's construction of faulty construction of road. That is the allegation. PIL.
There's no proof of this representation having been sent. We'll pass it over.
No action has been taken on the representation, my lord. Your lordship.
Where is the proof of sending the representation, sir?
That is, my lord, at page 14, my lord, email. I'll file fresh representation.
All right. Counsel for the petitioner seeks leave to withdraw the present petition with liberty to file a fresh representation. And after following up on such representation, to seek appropriate remedies in accordance with law. Disposed of is withdrawn with liberty is prayed for.
Item number 18.
This public interest litigation, my lords, is for the welfare of the stray dogs in the street. The manner in which they are being dealt with and the facilities which are obliged to be provided for them, they are woefully inadequate and not being properly manned.
When was your representation made?
The representation was made, my lords, right from Annexure 1, if your lordship sees, to the welfare board, then the municipality.
All right. You see the petitioner's representation.
And then, my lords, there is a notice.
And notice. Bracket annexes 2 and 3 shall be examined by the Commissioner, Cuttack Municipal Corporation, and after giving the petitioner a hearing, a reasoned order shall be passed thereon not later than 2nd January 2023. And a copy of the decision shall be provided to the petitioner within a week thereafter.
My lords, there is just one more prayer which your lordship may consider. There is a pound at Sartul where dogs are taken and kept when they're captured. Now, the problem is that we are not being allowed access to this pound. We have been debarred from entering the pound.
Why should you want to enter the pound?
Just to see whether they are being properly taken, because there is not even a bowl provided for water to the dogs. They are caged.
The commissioner will also facilitate a visit to the pound by the petitioner as part of considering her representation.
Right.
Item number 19.
May I please your lordships? Your lordship, this is a petitioner has challenged the first appellate authorities on GST.
All right. He has already paid 10%.
But entire tax amount has been paid.
All right.
So I request for stay of
the second appellate is on, a tribunal has not been yet constituted. The present petition is entertained. Notice, he accepts notice. Reply within 8 weeks, rejoined for the next date. In this IA number 1308022, you say counsel for the petitioner informs the court that the entire demanded amount has already been paid. In that view of the matter, it is directed that during the pendency of the present petition, no coercive steps should be taken against the petitioner. IA is disposed of. List on 2nd March.
Obliged.
Supplementary list item 20.
May I please your lordship? Your lordship, I am appearing on behalf of Mr. Adhiraj Mahantri. So this is a matter pertaining to cancellation of registration certificate. Your lordship, this is covered by your lordship judgment on 2nd of November 2022.
Coming on 5th December.
Sorry?
It's coming on 5th December or what is?
No, this is covered by lordship.
Show us towards.
See that cancellation
Subject to paying all penalties and all that.
Yeah, let's go.
All right, same order.
But it was cancelled in March 22.
Highly.
He's not objecting.
Item 21.
Same one.
Item for 20 and 21 are appearing for the opposite party number 3.
All right.
Item number 22.
May I please, Your Lordship, I am appearing through video.
Yes.
Your Lordship, on behalf of Mr. Acharya, I have instructions to appear in the matter. I'll enter my appearance. And Your Lordship, as instructed, the company has undergone CIRP and has been acquired by Tata Steel Limited. So necessary changes in the cost title also has to be made. So Your Lordship may kindly.
All right. Ms. Sahu, appearing on behalf of the petitioner, seeks time to file an appropriate application for amending the cost title at a request list on 8th March.
Supplementary list item 23. Item number 23.
None appears to exist. Oh, 9th March. There's already one case on the 8th March. We have to take it off.
Item 23.
None appears.
Item number 24.
May I please, Your Lordship? The petitioner was initially appointed as a lecturer. The petitioner was initially appointed as a lecturer in Odia in the Indira Gandhi Women's College. She filed writ petition before the Honorable Single Judge, claiming similar benefit granted to Women's College, that is granted on completion of 3 years, 1/3 3 years, 2/3 5 years, and 14 7 years, at par with other Women's College. My Lord, Honorable Single Judge of this Honorable Court rejected the claim of the petitioner on the ground that first post and other posts have not claimed granted on the principle of 3, 5, and 7 years, and others, and government extended granted on the basis of 5, 7, 9-year principle. Against the order of the Honorable Single Judge, I filed AHO, now writ appeal, before this Honorable Court, my Lord, and my writ appeal was dismissed. Your Lordship, kindly see page 82 of the impugned judgment of review before this Honorable Court, page 82.
Yes.
Paragraph 19, my Lord.
Yes.
Para 90. In the instant the case, the following facts remain undisputed. Your Lordship, para 1, there is nothing on record to show that appellant petitioner have never been appointed by issuing advertisement inviting application. In my pleading before the Honorable Single Judge, I have specifically avoided that advertisement was made, and on the basis of advertisement interview was made, and petitioner was selected for the post of.
Did you substantiate that averment is the question, sir? When the court says there is nothing on record, doesn't mean averment. Is there any material placed on record to show that there's this advertisement?
I have made pleading, which is not
pleading. Is not the same thing, sir. When the court is saying there is no material, there is nothing on record, means not pleading. There's no document on record.
My Lord, what I am, Lordship, kindly see, para 2, my Lord, the appellant petitioner had been appointed purely on temporary basis on salary of 400 per month, with effect from 1/3/86, and services were liable to terminate at any time without any notice. The appellant continued working under the said appointment letter and carried out the same status of the temporary employee without having any right in the post, my Lord. After my appointment, post was approved by the government, my Lord, on the basis of 5, 7, 9 years principle instead of 3, 5, 7 years principle, as has been extended to very college. Very college, my Lord, your Lordship's review has been filed on the discovery of a new evidence that, my Lord, in so far as very college is concerned, they extended to others. First post in psychology and second post in other disciplines.
So post being permanent also will not solve your problem. Your appointment is temporary.
My Lord, my post was approved.
Sir, post being either approved, regularized, or whatever, recognized, Your appointment to that post is a temporary appointment, sir. Please don't mix up temporary appointment with the permanency of the post. What the judge is trying to tell you, what the court is trying to tell you is your appointment was a temporary appointment.
My lord. My temporary appointment was made substantive and my post has been approved by the competent authority.
You are combining two sentences now. What has happened is your post was approved, the post became a regular post. Your appointment did not become regular.
Your lordship, kindly see in the review petition. I have enclosed, my lord, my service book that my appointment, I have given the scale of pay and after appointment was substantive.
There has to be an order for these things, sir. There has to be an order converting your temporary appointment to a regular appointment.
What my humble submit, my lord.
Yes.
Honorable single judge has held that
yes,
since the first post and other different disciplines have never claimed granted on basis of 3, 5, 7 years principle. 3 years, 1/3, 5 years, 2/3, and 7 years full granted being a woman's college.
Right.
And government extended to very college.
Right.
Other lecturers.
Right.
But petition is a handicapped person.
Right.
And during the course of employment, he suffered a handicap and 50% disability.
Right.
He has been discriminated and denied, my lord.
Right.
The benefit, my lord. Your lordship,
this is not an appeal, sir. This is a review
this
petition.
is not appeal, my lord. What I humbly submit, my lord.
Right.
In fact, advertisement was made, my lord.
Unless you show a copy of the advertisement, there's no point, sir. Mere averment will not do.
And your lordship kindly sees in very college, I filed affidavit also earlier today, in the very college, my lord, extended, my lord. And physical disability person, my lord.
So review petition, we have to be review petitions only if there's an error apparent in the face of the record. You have to demonstrate that. You're not arguing the writ petition itself. It's a review petition. You say no grounds made out for review. Review petition is dismissed. All right.
Item number 25.
None appears dismissed.
Item number 26.
None appears dismissed.
Item number 27.
Same order.
Item number 28.
Same order.
Item number 29.
It is permitted to withdraw, my lords.
Dismisses withdraw. Okay.
Item number 30.
Permitted to withdraw. Dismisses withdraw.
Item number 31.
None appears dismissed.
Item number 32.
Also permitted to withdraw.
Dismisses withdraw.
Item number 33.
None appears dismissed.
Item number 34.
Permitted to withdraw, my lord.
Dismisses withdraw.
Item number 35.
None appears dismissed.
Item number 36.
Same order.
Instruction.
Okay, no instructions. Dismissed.
Item number 37.
37, may I please, my lords. My lords, this review application was filed with a delay of about 260 days. So lordships allows my condemnation petition, then only I'll go to the merit.
There's a delay of 245 days in filing this review petition, which has not been properly explained. Consequently, the MC number 212 of 2009 is dismissed. Consequently, the review petition is dismissed.
Item number 38.
May I please, your lordship?
Yes, please.
Well, the petitioner went to the opposite partner file and found and got the information that he has already received the notice which has been issued by this honorable court through registered post. And it is stated that the state will take instruction from OP number 5.
We have received a letter saying that we will be representing. My lords, may give me a month's time. I file my reply.
All right. Counsel appearing for respondent 5, opposite party number 5, seeks an adjournment for instructions. List on 2nd March.
Lordship, it is the matter of 2012. Lordship, the system, the sanitary system has not been developed here.
All right.
A short date maybe, my lord.
This came up on its own, sir. But you had not mentioned all this. We are only taking up all these old matters.
No, I have been mentioning, my lord, for several occasions.
Anyways,
Because though, my lord, your lordship
All
is
right.
pleased to monitor this, my lord, then there is no requirement for filing mention memo.
All right.
I had also mentioned earlier.
Okay, sir. Okay.
Item 39.
May I please, your lordship, my lord, item 39, kindly 1 week time will remove the defect.
All right. If I moved within a week, list thereafter.
All right, your lordship.
Item number 40.
May I please, your lordship? My lord, it's a public interest litigation. My lord, admittedly, a
The
lease has been.
defects, what about defects?
My lord, those defects are legible copies of the signatures of the persons who had moved the representation. That is the defect I had checked up, subject to correction by your lordship. Other papers, there is no defect, madam. When it is uploaded, those documents, the signatures were little hazy, that's the problem. Copies have been served to the state. Everything is there.
You seem to have received the representations because you issued a order on 3rd June.
Representation, made an inquiry, directed that it should not, the embankment should not be dangerous. Still then, my lord, they are not taking any action.
All right.
It is their report.
All right. It is notice. Mr. Manthi accepts notice for opposite parties.
I only bring
1 to 5.
Your lordship may
Notice now be served on opposite party number 6 returnable on the next date. Replies, if any, be filed within 4 weeks to join up for the next date.
I was praying one thing.
Yes,
Subject to,
please.
if your lordship may kindly allow me to address your lordship. My lord, here, thousands will be marooned. So your lordship may monitor it.
No, that's right. We're giving a date only, sir. Let the opposite party number 6, your main
Yes,
that lessee has to
contesting
be
party is
Yes.
opposite party number 6.
Yes, yes. My lord, I'll take notice by registered post.
Right, registered speed post. Correct.
My lord.
Ah.
I'll serve one extra copy to the state.
All right. 9 December.
Next case I have filed, my lord. Let them not damage the embankment. Let them continue with the lease. I don't say on the
Let
lease.
them come and tell us
My lord,
what
if the embankment is damaged,
Correct.
my lord, if they take away the entire sand, the entire embankment, entire 5 villages will be marooned in the floods.
9th is what is the next working day?
Your lordship may direct that the state authorities should ensure that the embankment is not endangered. This is the only miscase I'm praying.
19th December.
Yes, 19th December.
Item 41.
My lord, but it's a matter, my lord, related to the repair of the that is the CC road, my lord. So government money is sanctioned for repairing of the CC road, my lord. The entire villages have are faced severe problem because of the blocking of water. But the main road of the CC road, my lord, that's been blocked by
All
water.
right. The petitioner's representations, bracket Annexure 1.
Yes, ma'am.
Shall be examined by the collector then canal.
Yes.
And after notice to the petitioner as well as opposite party number 5. Giving them a hearing, a reasoned order shall be passed thereon, not later than 2nd January 2023.
Yes.
And be made available to the parties within a week thereafter.
Yes, ma'am.
The court clarifies it has not expressed any view on the matter.
Okay. Obliged.
Item 42.
Item 42, not here, pursuant to public notice, the ward members of Kodinga Gram Panchayat have filed objection under Annexure 3 series. And also police have also passed resolutions that they do not want conversion of from beer parlor to IMFL on-shop. And under rule for section 41, the collector is the authority to.
Objection should have been considered.
Yes, objection must have been considered.
No.
My lord, I am for the OP number 5 licensee. Today I am
Lordship may direct that the objections will be considered by the collector as per section 41.
If not already considered, the objections of the petitioners, bracket Annexure 3 series.
If any pursuant to the Form 8 notice, that is very
Yes, pursuant to Form 8 notice. That has been referred in the police Sabha.
Pursuant to the Form 8 public notice shall be
Under Annexure
considered
2.
by the collector.
Collector Navarampur.
District office will
Collector Navarampur.
And after notice to the petitioners as well as opposite party number 5, and after giving them a hearing, an appropriate order shall be passed there or not later than. There's supposed to be some statutory time period for this?
No, my lord. There is no time period is there.
They have
because
to submit we don't just within the stipulated period, they have to file the objection. and thereafter it will be considered. After it is complied, then the collector will.
No. Should we give 1 month's time or 2 months time for this?
No, because we do not know whether their objection has already been considered.
No. We have
15 days.
On
within
10th,
15 days.
10th November, the date has been expired. The public notice period is on 10th 11.
All right.
In that
So
case,
just
On
without
12th December 2022, and be made available to the parties within a week thereafter. The court clarifies it has not expressed anything in the matter.
Published.
Allah, my presence may be noted.
Yes.
Item number 43.
43.
Pass over.
Item number 44.
None appears dismissed.
Item number 45.
None appears dismissed.
Item 46.
My lord, may we permit 1 week time to remove the defect? Item number 46.
Defects be removed within a week list thereafter.
My lordship, item 45, my lordship. No
Yes.
instruction, my lordship.
No instructions dismissed. 45. All right.
Item 47.
May I please, my lord? There's one defect, my lord. I have solved the copy today morning, so it's just
now I
my lordship permit, then I'll proceed. Authorize, my lord. If he says
Just now I received the copy.
it is a case, my lord, the revisional order under the challenge. Non-compliance is honorable court settled principal law decided in one case.
You don't go to the tribunal, is it, against this?
No.
Why?
It's not tribunal. It is a revisional order before this High Court. There is no other alternative. Second order application. I have come up against, then pass the order, then will come up again before this honorable.
No. Against the impugned order of the commissioner.
No. Commissioner that directly met. There is no tribunal.
I see. Notice, then he accepts notice. What is the
issue here is not a non-speaking order has been passed and imposed penalty, and you see.
All right, let him file counter then. Notice he accepts
Yes.
notice.
Yes.
Reply we file within 8 weeks. Rejoined for the extent. List on.
Item 48.
This matter, I have instructions to appear, my lord, for petitioner. Many defects, my lord, I must be given some time to remove them.
All right. So defects be cured within a week. List thereafter. All right.
Greatly obliged.
Item 49.
Defects are here also.
My lord, in item number 49, I have already sought the copy, and the 7 is regarding capital letters in Oklahoma.
All right. What is the matter about?
Matter about cancellation of registration certificate against which was preferred. And this honorable court, by a historic judgment, very lucid historic judgment, similar order may be passed at paragraph 13 of the my lord. Your lordship may kindly see para 13. That is the operative part of your lordship's order.
All right.
So may I read the order, my lord?
One minute. Is it covered?
Your lordship, CGS, Central GS. I am appearing for CGS.
Is it covered?
Covered.
Or
similar orders have been passed on this 7th.
Or you see in the notice, he accepts notice. Both parties agree that the issue raised in the present petition is completely covered in favor of the petitioner by the judgment dated 13th October 2022 in writ petition civil 7728 of 2022, Messrs. Durga Raman Patnaik versus Additional Commissioner of GST. So accordingly, the following directions are
para 13, my lord.
Yeah, issued. Just copy from para 13. Yeah. All the whole of para 13. Right. All right. The petition is disposed of their workers.
Item number 50.
My lord, item 44. Item 44.
Called it out, sir. You'll have to wait. Who's on item 50?
Item 50.
May I please, my lord, item number 50, the consequential order, they have accepted the return, it becomes infructuous.
All right.
Kindly
Counsel, the petitioner states that this petition has been rendered infructuous. Is disposed of this.
But I may appeal soon.
Yes.
Item 51.
May I please, my lord? My lord, item number 50, I have challenged 148 notice, which has been passed beyond the period of limitation. Assessment year is
This is 51.
51.
Yes. Item 51. Assessment year is 13-14. The notice has been issued on the last date of limitation, that is 31/3/2020.
That is within.
And it has been, they have accepted is beyond time and they are taking help of TOLA. And similar judgment has been passed in Ambika Steel, where this has been considered.
But here, my lord, it is within 6 years, my lord, 13-14. From 13-14 within 6 years, that may be the last.
They have created the dean in the very last day of limitation, but served the notice much after that.
When did you serve the notices?
In the last 2 pages of the writ petition, I have enclosed proof of
1-5.
Page 23 and 22.
Yeah.
1-5, these are 2020. They have actually.
What did you say in your counter? What have they said in the counter, sir?
In counter, my lord, we have said that time limit was extended. For that has been served in time. But that was issued as per.
When was it served on him?
No, my lord,
There must be an averment in regard to annexure 2.
No, my lord.
Which paragraph of the writ
No, my lord.
petition?
Specifically to that extent, we have not.
These are part, my lord. The notice.
Para 4. Para 4D. What is the reply? Correct. Para 4D. There's no reply to para 4D, sir.
No, my lord. And my lord, this apart, this notice has been issued against a dead person. Sipson has been already dead, and it's a null and void.
All right. There are 2 grounds in which the impugned notice, Section 48 of the Income Tax Act 1961, Bracket Act, dated 31st March 2020, has been challenged by the petitioner in the present petition. So first is that it has been issued against a dead person, inasmuch as the.
And I rely upon the Delhi High Court judgment where they have said
the assessee, deceased assessee, expired on
17th of February 2018.
17th February 2018. Where have you said that, sir? Which paragraph?
In fact, we say it is not nowhere. As
my God, you're not even awarded.
Yes, my lord. I am extremely sorry. It is
then,
nowhere.
Then we can't even consider it, sir, because they've not even had an opportunity to reply. Then you say that the ground on which the impugned notice dated 31st March 2020 under Section 148 of the Income Tax Act 1961 Bracket Act has been challenged is that the notice was served beyond the period of 6 years after expiry of the relevant assessment year bracket AY, that is 2013-14. Paragraph in para 4 bracket D of the petition. It is averred that the said notice was in fact dispatched the 4C, it is averred that the notice was in fact dispatched through post on 1st May 2020. And therefore, this notice was not served within the period limitation. Full stop. Annexure 2 series contains the relevant document showing that the dispatch happened only on 1st May 2020. In the counter affidavit filed, there has been no denial whatsoever of the said averment. Stop. Paragraph. Although there is a second ground urged that the appellant that the petitioner had already expired on 17 February
2018.
2018.
Yes.
And therefore notice was issued to a dead person. There is no such pleading in the petition itself, and therefore there is no opportunity to the department to answer the said point. Full stop. Paragraph. Nevertheless, since it is apparent that the notice was dispatched to the petitioner only on 1st May 2020, that is beyond the expiry of 6 years after the end of the relevant assessment year, it is plain that the initiation of the proceedings under Section 148 of the Act was time-barred. Stop. In view of the decision of this court dated 24th January 2022, in writ petition civil 20919 of 2021, bracket, Ambika Iron and Steel Private Limited versus Principal Commissioner of Income Tax, bracket. The impugn notice and all proceedings consequent thereto hereby quashed.
Item number 52.
Much obliged.
52.
May please, Your Lordship. Your Lordship, defect number 6, I have removed. I have
Just now I have received the copy.
Okay, all right.
Your Lordship, in spite of that, Your Lordship, this is 74 order, an appealable order.
May, Your Lordship. Kindly have a glance at page 32. The impugned order. Second para, second line. As per electronic records available in GST, it is found that you have made voluntary payment amounting to 45,000 under IGST through DRC 03, dated 18/5/2019, by utilizing ITC laser in tax period March 19. And this is the order for March 2019. And in the order, they have admitted, I have paid the tax, but utilizing ITC laser, credit laser. And pursuant to that, Your Lordship, already a circular has been issued saying that I can use that. And matter is only 45,000 and the sole proprietor is died in the meantime. It is filed by the widow, 45,000.
Your Lordship, so plus I will take instruction.
All right. Notice, accepts notice.
The circular I am placing in it.
Ms. Roy Chaudhary has placed in record copy of the circular dated.
Because Your Lordship, this cannot be said as voluntary payment as per return, Your Lordship. This is not as per pursuant to the
Then we
return.
file a reply. Circular dated 6 July 2022 of the Central Board of Indirect Taxes and Customs. GST policy permitting
point number
payment
6.
Payment of tax by utilizing the
Point number
tax credit.
6. Yes, point number 6, Your Lordship.
Yeah, which appears to be the only ground on which proceedings were initiated against the petitioner, against the husband of the petitioner. Paragraph. A reply be filed within 4 weeks, rejoinder of the next date. See, till the next date, no coercive action should be taken against the petitioner.
Oblast.
2nd March.
Oblast.
Item 53.
I may permitted to rectify the defect by next week.
All right.
And apart from that, my IA number 74948, I may permitted to withdraw and file a fresh because some pages are missing. So
all right. In the main writ petition, it said defect be cured within a week. List thereafter. In IA number 7948 2022, counsel for the petitioner seeks leave to withdraw this application with liberty to file a fresh proper application in accordance with law. Disposed of is withdrawn with liberties paid for.
54.
Defects.
My lord, the defects is copy has already been solved. 7 is regarding Okilatnama and the 11 is the certified copy they have issued. Department has issued the screenshot of the certified copy which has been filed before your lordship. My lord, in this case, refund has been disallowed on the ground of delay by setting over the judgment of the Honorable Supreme Court, extending the period of limitation. And that is the whole issue.
Right. Notice. Who's for the respondent? He accepts notice.
The copy.
Copy of this be served on him. Reply we file within 8 weeks. Journal for the next date. 10th March. Sorry, 9th March.
Obliged, my lord.
9th March.
Item 55.
55 ballots, I may be permitted to remove the defect. Your lordship may call this matter next week.
All right. Defects we cured within the week thereafter.
Ballots, can it be next week?
Item 56.
Yeah, next week. Yeah.
Yes, great. Great.
56.
Well, I've challenged the first appeal order under the GST Act. So similar order subject to payment of 20%.
All right.
Yeah, appearing
Since the second appellate tribunal is not yet constituted, the petition is entertained. Notice. He accepts notice, reply within 8 weeks for the next date. In the IA number 14206, counsel petitioner states that at the stage of same, just take this. And date will be not 2nd February. Date you put it as 15th March.
I am appearing for opposite party number 5. A copy may be kindly served to us.
And for 1, 2, 3.
Item 57.
My lord, no instruction, my lord.
No instructions dismissed.
Item 58.
Item 58, I am appearing. I file could not be traced. Can I pray next week? I will try to.
So we'll dismiss it. Whenever you trace it, you can revive it.
Time to file a reply to the review application.
No. See, review petition counsel, the petitioner states he is unable to trace the file. The petition is dismissed for non-prosecution, so with liberty to the petitioner to revive it in the event that the petition is able to be traced. Yes.
Item 59.
None appears dismissed.
Item number 60.
None appears dismissed.
Item 61.
My lord, 60. My lord, item 60 and here. 60.
Item 60. Item 60.
May please, your lord. My lord, I am filing a review application. I am challenging the order passed by this honorable division bench under Annexure 8. My lord, I have only 2 points involved in this review petition. My lord, I was initially appointed as a teacher on 7/7/83. As per the 18 Act, those are appointed prior to 1/12/76 and 31/12/84. His service will be validated under the Validation Act 1989. My lord, this thing was not taken into consideration in this order passed by this honorable division bench. Number 2, my lord, there are 2 things, my lord. A person whom he has most rendered 1 year of continuous service, and those are appointed prior to the 1/12/1976 and 31/12/80/84. His service will be validated under the Validation Act. Under the Validation Act 1989. This was not taken into consideration. My lord, what has happened, my lord? I was initially appointed as a trained graduate teacher in the year 83. My service was terminated. I have filed a writ application before this honorable court. This honorable court disposed of this matter with a direction to the inspector of schools to adjust me in nearby place of posting. They have adjusted me against the nearby school. But they have not taken into consideration 83. That service period was not taken into consideration.
The same point. These are not points for review, sir. This is a point for appeal.
No, my lord. My lord, my lord, kindly see this order, my lord. First. I have taken the amendments in the original application, writ application. That was not considered, my lord.
It's all right. No grounds made for review. The petition is dismissed. Right.
Item number 61.
61, my lord, not pressed, it is
Not pressed, dismissed. All right.
Item number 62.
May I please pronounce? Your lordships have admitted 3 questions of law by the order dated 13/7/2022, my lords. So those questions of law at that page 6 of my brief, my lords.
B, E, and F.
B, E, and F, my lords. So may I just place the questions of law before I place the matter, my lords? So whether the tribunal is justified in restoring the order of reassessment undisputedly when the reassessment was made on mere change of opinion of the assessing officer, my lords. The second question, my lord, is whether the tribunal is justified in holding that spare parts of cycle and cycle rickshaws were liable to tax at the rate of 12% prior to 1/4/2001. And the third question, my lord, is whether the tribunal is justified in holding that the components and spare parts are 2 different things, hence to be interpreted separately for the purpose of levy of tax, my lords. So my humble submission would be that if your lordships are with me, so far as the first question regarding change of opinion is concerned, my lord, your lordship need not go to the other 2 involving the rate of tax.
Correct.
Here, my lords, what has happened, my lord, is initially the petitioner was assessed under section 12(4) of the OST Act, my lord, which is the regular assessment. Then basing on an audit report, my lord, this was reopened under 12(8), my lords. It was found out, my lord, against the 12(4) assessment, where my returns were accepted. The rate of tax was determined to be 4%. That was accepted, my lords. I went up in appeal for that particular year against the 12(4) order for other reasons, my lord. It was not interfered with. And as your lordship knows that the first appellate authority has the powers of enhancing or the powers of also, that power is also not exercised, no, that was concluded, my lord. The state never went up in appeal, my lords. In the present case, my lord, basing on that audit report, my lord, on the ground that spare parts should have been taxed as an unspecified item at the rate of 12%, my lords, the 12(8) proceeding was completed, my lords. I went up in appeal, my lord. The first appellate authority decided in my favor. Then the state went up in second appeal, and that was reversed, and the assessment under 12(8) was restored, my lords. Before the tribunal, my lord, if your lordship would kindly come to the tribunal's order, my lords. It begins at page 24. I just take your lordships to page 25, my lords. This very fact of change of opinion, may I just place paragraph 3, my lords?
Yes.
Being agreed with the order of assessment, the dealer respondent approached the first appellate authority by way of filing an appeal in which it was urged that completion of reassessment under section 12(8) of the Act is illegal, arbitrary, and has no basis, since the dealer has furnished true and correct particulars of his return, which were considered by the learned STO at the time of assessment under section 12(4) of the OST Act. Thus, reopening the assessment, basing on the objection received from the audit, is against the principle of law and hence liable to be quashed, my lords. So this, my lord, was involving a question of change of opinion also, my lords. Unfortunately, my lord, at paragraph 6, if your lordship would see, my lords, the tribunal never discusses this issue, my lords. They go on the ground, on the premise, my lord, that spare parts was introduced with effect from 1/4/2001, my lords. At the relevant point of time, my lords, the cycle rickshaws and cycles, including accessories and components, was also there. Spare parts was not there. So since spare parts came into effect from 1/4/2001, it should be under the residuary entry and taxed at 12% instead of 4%. My lords. So this particular issue of change of opinion was never there, my lords. And once I have specifically pleaded before the authorities that I have been assessed under 12(4), that matter was carried in appeal. It was not disturbed in appeal, my lord. That 4% was accepted. In the first appellate authority, my lord, he discusses extensively, my lord. He says, my lord, it is 4%. State goes up. I raised this question specifically. It was not answered. Now, so far as the change of opinion is concerned, your lordships are well aware of those judgments, my lord. But for your lordship's kind convenience, I'll just place reliance on this honorable court's judgment in India Limited, my lord. May I just... If your lordships are with me in this point, I not bother your lordship of the other two.
Your lordship, I think the other 2 points are
can be left open.
No, Your Lordship, other 2 points are more favorable to the dealer, Your Lordship, instead of this point.
Yeah.
In my opinion, Your Lordship.
That will be my second.
In my
Hindustan Sanitary.
Sorry, Milord?
Hindustan Sanitary.
Milord.
Honorable Apex Court has settled that.
Because
both are equal.
No, here what has happened, Milord?
Component.
May I just place this, then I'll go to the read to fact. Your Lordship, may kindly straight away come to paragraph 6, Milord.
Yes.
Because so far as this issue is concerned, so far as the 12-8 and change of opinion, Your Lordship, this aspect has already decided by this Honorable Court in Bindli's Chemical and Uttareshwar Rice Mill, while Your Lordship adjudicating so far as that initiation
Bindlish has been discussed in this case.
43 proceedings.
As well as Uttareshwar, Milord.
It is in that 43 reopening Your Lordship has discussed. Your Lordship, this is 12-8 for the language is for any reason.
May I just place it, before my learned friend?
Let him finish and then you can.
Your Lordship, may kindly turn. So let me answer this question first, Milord. Language of 12-8, Milord, was first reasons to believe, Milord. Then it was amended, Milord. It said for any reasons. That is also discussed, Milord. But unfortunately, the form which was there, which is a part of the statute, there, Milord, at page 2, Your Lordship would see. There they have discussed the form. Let me place the form, Milord.
Yes.
The subject matter of challenge in this writ petition is initiation of a reassessment proceedings by the state of Odisha sales tax officer by notice dated 23/9/1998, purported to have been issued under section 12(8) of the Odisha Sales Tax Act. The impugned notice was issued in a statutory form, being Form 6 under the Odisha Sales Tax rules. The material part of the recital contained in the said notice is as follows. Then the Lordship may straightway come to the third paragraph, Milords. As I have reasons to believe that your turnover of sales and or purchases for the quarter ending so and so on the which taxable tax payable under the Odisha Sales Tax Act 1947 has escaped assessment or has been under assessed, has not been assessed due to the tax so and so. So their Lordships, Lord, have also discussed this aspect that even though 12(8) does not contain the reasons of the language reasons to believe, since the statutory form contains the reasons to believe, my lord, it will be construed as if 12(8) also has reasons to believe embedded in it, my lords. Because they have referred to the form first, my lords, and then if your lordship would kindly come, my lords, to the paragraph 6, my lords. I'll just come to small Roman 4, my lords.
Yes.
Whether the expression for any reason in section 12(8) of the OST Act gives wider powers to the authorities to reopen assessment than the words reasons to believe, and whether the exercise of power under section 12(8) of the OST Act has to be consistent with the statutory rules and in accordance with the statutory forms framed under the Act. Now, this question has been answered, my lord, paragraph 7, my lords. May I just please it, my lords?
Yes.
Question number 4 raises some points of statutory interpretation and is taken up first for consideration. For the proper appreciation of the points involved, the provisions of section 12(8) of the OST Act is set out. I need not bother your lordship with the entire thing, but just the first place, if for any reason. Your lordship got it?
Yes.
Then your lordship skips over that's an entire extract of 12(8). Then the lordships also extract to rule 23, my lords.
Right.
The second line, my lord, if for any reason.
Right.
I need not bother your lordship with the rest of it, my lords. Then the third paragraph, then the lordship discuss about the third paragraph of Form 6. Whereas I have reasons to believe. Your lordship got it?
Correct.
It is then this the lordship says it is important to note that these rules being framed under section 29 of the Act are to be laid before the state legislature in view of the provisions of section 29A of the Act. So the rules are part of the Act. This that is the clear statutory dispensation. Then your lordship may kindly come to my lord paragraph 8, my lords. While the court is scrutinizing the exercise of powers by the authority under Section 12(8) of the OST Act, the entire gamut of statutory provisions contained in the rules and the forms are to be kept in its mind. It cannot be said that, in fact, it has not been said by the revenue that any part of the statutory rules and forms is redundant, or that the power under Section 12(8) of the OST Act can be exercised ignoring the rules and the statutory forms. In fact, it was not so exercised, and the impugned notice was issued the statutory form, the relevant part of which has been set out previously. Then the Lordships rely on the decision of Uttareshwari, my lords.
Correct.
I'll just skip that. I'll just come to the next page. While reaching the, your lordship got it?
Correct.
While reaching the aforesaid conclusion, the apex court held the difference in phraseology between if for any reason and if the sales tax authorities has reasons to believe does not make material difference. The other two observations, your lordship would see, in coming to this conclusion, the apex court took into consideration Rule 23 of the said rules in Form 6 referred to in Rule 23 and also the relevant recitals in Form 6 which has been set out above, whereas I have reasons to believe. The sales tax authority issuing the notice should have reasons to believe that the turnover of a dealer has escaped assessment or has been underassessed. Reasons cannot exist in vacuum, my lords. The approach of the court should be practical and not pedantic, my lords. Then their lordships refers to Bihar agriculture in paragraph 9, my lords. May I just please?
Rameshwar Singh.
My lords. Then my learned friend was mentioning Uttareshwari and Bindalish.
Yeah.
May I just place this the subparagraph
of
paragraph 8, my lords? But in Uttareshwari rice mills, the apex court specifically considered the provisions of Section 12(8) of the OST Act, Rule 23 of the rules and Form 6, which are relevant statutory provisions here, and held that the difference in the phraseology between for any reason and if the sales tax authority has reasons to believe does not make much of a difference. But unfortunately, the attention of the division bench, which rendered the judgment in Bindalish, was not drawn to the decision of Uttareshwari Supra, my lords. That was the objection which my learned friend.
No, but if they come to the same conclusion, doesn't matter.
Sorry,
it's noted here that in Bindalish also they say there's not much of a difference.
Much of a difference. No, my learned friend was
the same conclusion was reached.
My lords.
In Uttareshwari.
My lords. Then, my lords, Ugratara Bhojanalaya in paragraph 11 was also considered. There, their lordships have said, my lord, the subsequent division bench judgment of Odisha's High Court in State of Odisha versus Ugratara Bhojanalaya reported in so and so, in my judgment, explains the requirement of Section 12(8) of the OST Act in consonance with the views of the apex court in Uttareshwari Supra, since the judgment in Uttareshwari was cited before the division bench. Accordingly, the division bench held that the legislative intent in Section 12(8) of the OST Act is apparent from the words used in Form 6, in which the words "whereas I have reasons to believe" finds place. Therefore, the division bench held, following the dicta of the apex court in Uttareshwari, the different phraseology between for any reasons and if the sales tax authority has reasons to believe does not make any material difference. The lordship will skip over it and come to paragraph 14, my lords.
Correct.
The concluding part. Lordship got it?
Yes, yes.
So after considering all the decisions cited on this point, this court feels bound by the interpretation given to Section 12(8) of the OST Act by the apex court in Uttareshwari Rice Mill Supra, which was subsequently followed in Ugratara Bhojanalaya Supra. Following the above aforesaid ratio, this court reiterates that the difference in phraseology between for any reason and where the sales tax officer has reasons to believe does not make any material difference in view of the provisions of Rule 23 of the said rules, which mandate that the notice for reopening has to be in Form 6, and the Form 6 uses the expression where the sales tax officer has reasons to believe. So, the question number 4 is answered by holding that the words for any reason in Section 12(8) of the OST Act do not give wider powers to the authorities to reopen assessment compared to words reasons to believe, since the words to believe are incorporated in the statutory form in which notice of assessment is to be issued. The court also holds that while exercising power under Section 12(8) of the OST Act, the authority has to act consistently with the statutory norms prescribed under the statutory rules and the forms. In Uttareshwari construing Section 12(8) of the OST Act, the Apex Court held that the sales tax officer issuing the notice should have reasons to believe that the turnover of a dealer has escaped assessment or has been underassessed. The Apex Court further held that the approach has to be practical. Then the Lordship need not come to the
I think
rest.
that 15B and C is important.
My Lords.
Your Lordship,
15B.
Your Lordship has already decided the issue in favor of the petitioner, Your Lordship.
I'm obliged. I'm obliged.
So from the beginning, I'm trying to say, so Your Lordship has already decided. Only Your Lordship at page 17, the 12(8), the case is reopened under Section 12(8) by receiving AG audit report, Your Lordship. So, Your Lordship, what I pray, Your Lordship, let me call for the record, Your Lordship. The assessment, if the assessment record, the personal satisfaction of the assessing officer is there, then Your Lordship, I have a case. If there is no personal satisfaction, then this case law, what Your Lordship has decided after cognizing all the judgments, Your Lordship, is covered by that judgment, Your Lordship.
Would have been produced before the tribunal, because here's a case where I have specifically raised
to the tribunal.
No, I have
to call for the
at this
Might
point
as well have the record produced here, Mr. Karan.
But that will not be germane to this issue.
Mr. Karan places reliance on the judgments of this court in the Indure Limited versus Commissioner of Sales Tax 102 2006 CLT 309 and the subsequent decision dated 13 July 2022 of this court in STRAV numbers 26 of 2013 bracket Messrs. Tree Nuts India Private Limited versus State of Orissa. Paragraph, Mr. Mishra Leonard, Standing Counsel for the Department, states that he will produce the original record for the court, assessment record before the court on the next date in order to ascertain whether the assessing officer had recorded his personal satisfaction on single quotes, reason to believe, unquote, regarding escapement of turnover from assessment on the basis of the audit objection.
I do
list on. February 7th.
I reserve my right for the other two regarding rate of issue.
Your Lordship, other two grounds are very much favorable to the dealer, to the petitioner, Your Lordship.
And if that is in my favor, that should be allowed, my lord. I give up if my learned friend concedes. I give up the first point, my lord. So the entire exercise,
I'm not ready to concede. It can be decided. So it can be decided.
97-98 assessment record.
Sorry, my lords.
97-98.
97-98 assessment, my lords.
Your Lordship knows very well what.
And if my learned friend, my lord, says that I succeed in the other 2 points, my lord, I'll not raise this issue.
This is my opinion out of court, but I cannot concede because it is the revision petition. The question of law is to be decided.
You'll never get it.
So in those, from my
lord knows very
so my personal opinion, but from my personal experience, my lord, I only not say that these factors which were later on, my lord, found out and was decided against the revenue was never looked into, my lord, at a particular point of time, lords. And your lordship shows the instances of completion of section 39 before initiating 43 of the OVAT Act, lords. We tried many a times, failed. And ultimately, your lordship's decisions came.
My lord has decided the audit report and also Honorable Supreme Court that audit report can be a reason, but it is the assessing officer has personal satisfaction against that reason. So that can be a reason for reopening.
All right.
And that particular reason is never found in the docket book. I can't say about this particular case.
Once that has been confronted, also my learned senior knows very well. Once that has been confronted, means that has been supplied.
Take the place of reasons to believe of the officer concerned.
Correct. All right.
Item 63.
What you pleasure.
May it please your lordships. My lords, in this matter, the appeal which was filed by me, the statutory appeal, has been decided, my lords. So I'm seeking liberty to withdraw this writ petition so as to file a fresh writ petition against the said order, my lords.
All right. Counsel for the appellant. Petitioner seeks leave to withdraw this petition with liberty to file a fresh petition. Challenge the subsequent appellate order, is it?
Yes, my lords.
Yes. Appellate order.
All right. In accordance with law, disposed of is withdrawn with liberty is paid for.
No, sir, I'm appearing for opposite party number from CDM.
Item number 64. Item 64.
64, I am appearing for the opposite party, my lord, petition. If your lordship permits me,
सर आई एम पिटिशनर इन पर्सन पिटिशनर नंबर 1 आशीष कुमार सर मैं करना चाहता हूं सर सम जजमेंट्स प्लीज सर जजमेंट्स सर एक कॉपी सर एक कॉपी
What's the flag 100 minutes? Flag 100 is
Sir, continue करें sir?
Yes, please.
The Supreme Court in state of Odisha and others versus Prasanna Kumar Sahu reported in 2007-15 SCC 129 their lordship of the Supreme Court of while dealing with the similar situation of conflict between executive instruction and statutory rules in para 13 of the reported held the under. Sir, orange flag, sir, para 13, sir.
Right. Even a policy decision.
Even a policy decision taken by the state in exercise of its judicial section under Article 162 of the Constitution of India would be subsequent to the recruitment rules framed by the state either in terms of a Logistic Act or the proviso appended to Article 309 of the Constitution of India. A purported policy decision issued by way of an executive instruction cannot write statute or statutory rules, far less the constitutional provision. Sir, executive order only supplementary. This is a policy decision, sir.
Yes.
Sir, my second judgment, sir. Sir, second judgment in the Supreme Court of India, Civil Appeal number 4977 of 2019. Sir, para 10, sir, flag pink, sir.
Yes.
Neither the circular dated June 1982 nor the subsequent circular dated 19 March 1982 modifying the earlier circular dated June 18, 1982 can override the statutory provision contained in Rule 17B of the Code if it result in reduction of pay of the employee on promotion that Odisha Service Code has been framed under Article 309 of the Constitution of India is not a dispute. It is well settled that
statutory rules framed under Article 309 of the Constitution can be amended only by a rules or notification duly made under Article 309 and nor otherwise whatever be efficiency of the executive order or circular or instruction. Statutory rules cannot be altered or amended by such executive order or circular or instruction, or can they replace the statutory rules. The rules made under Article 309 of the Constitution cannot be tinkered by the administrative instruction or circular. Yes. Sir, third judgment है sir, in the Supreme Court of India, civil appeal versus State of Bihar. Yes. Sir, para 17 and 18, para 17. Yes. It is well settled that the principle of estoppel prevent a candidate from challenging the selection process after having failed in it, as entreated by the court in a plethora of judgment, including Manish Kumar Sahi versus State of Bihar, observing as follows. We also agree with the High Court that after knowing taken part in the process of selection, knowing well that more than 19% marks have been earmarked for Viva test, the applicant is not challenge the criteria or process of selection surely if the applicant name had appeared in the merit list. He would not have even dreamed of challenging the selection. The applicant invoked the judicial section of the High Court under Article 226 of the Constitution of India only after he found that his name does not figure in the merit list prepared by the Commission. This conduct of the applicant clearly disentitles him from questioning the selection, and the High Court did not commit any error by refusing to entertain the writ petition. The underlying objective of this principle is to prevent candidate from trying another shot a consideration and to avoid an impasse wherein every disgruntled candidate having failed the selection challenge in it the hope of getting a second chance. Para 18, sir, important para, sir, in this case, sir. Yes. However, we must differentiate from the principle insofar as the candidate, by agreeing to participate in the selection process, only accept the prescribed procedure and not the illegality in it. In a situation where they create illegal misconstruction of statutory rules and discriminating consequence arising therefrom, the sum cannot be condoned merely because a candidate has partaken in it. The constitutional scheme is sacrosanct and its violation any manner is impermissible. In fact, a candidate may not have locus to assail the incurable illegality or derogation of the provision of the Constitution unless he participate in the selection process. That the petitioners as well as the pro forma respondent who had offered their candidature for the post of danger building worker semi-skilled present to advertisement under Annexure 1, keeping in view the statutory recruitment rules, namely Ordnance Factory Group C and D, Industrial Force Recruitment 1994, SRO Rule 185 in the exercise of power Article 9 in the present writ application seek to challenge the judgment date 30 September 21 passed by the Learned Central Administrative Tribunal, Cuttack Bench in OA number 445 of 2019 on the ground that the same is illegal, arbitrary and not sustainable in the eye of law in as much as the same is contrary to the principle of law laid down by the humble apex court in container of judgment In
My
consequence,
lord, since my learned friend is reading the petition, starting from.
no, sir, this is the most important clause, sir. Challenge is the final select list and order dated 5/4/2005 passed by the opposite parties and executive instruction date 17/10/2013 as illegal, illegality and contrary to the provision of recruitment rules, sir. So, sir, page number 162, order passed by the opposite parties, sir.
Whatever my learned friend is submitting, I am not disputing those things. That is why I was saying, my lord.
सर हमारा सर सबमिशन कर दें, उसके बाद सर रिस्पोंडेंट सबमिशन कर दें, अभी इंटर नहीं करेंगे सर. सर रिस्पोंडेंट हमारा सर जो है कंटेंशन है कि हम फाइनल सेलेक्ट लिस्ट को चैलेंज किए थे सर. एडवर्टाइजमेंट पब्लिश हुआ, हम अप्लाई किए, एग्जाम दिए सर, परीक्षा पास किए. उसके बाद हमारा जो आया कि डॉक्यूमेंट वेरिफिकेशन एंड टेस्ट के लिए हमारा एडमिट कार्ड इशू हुआ सर. ऑल द डॉक्यूमेंट वेरिफिकेशन, बायोमेट्रिक सब कुछ कंप्लीट हो गया. 4 months आफ्टर फाइनल मार्कशीट सर आया हमारा. और 3 अगस्त 2018 को सर हमारा फाइनल रिजल्ट पब्लिश हुआ, तो उसका नाम नहीं था सर फाइनल रिजल्ट में. बट कट ऑफ लिस्ट नहीं पब्लिश हुआ था सर. कट ऑफ लिस्ट फाइनल रिजल्ट के साथ साथ सर पब्लिश होती है, बट कट ऑफ लिस्ट आफ्टर 6 months सर पब्लिश हुआ सर. तो हम विदाउट कट ऑफ मार्क हम ओए गए सर. ओए हमारा डिस्पोज ऑफ हुआ, बट उसमें कट ऑफ लिस्ट ना आने से मेरिट लेस हुआ केस सर. पैरा 9 जो है कट ऑफ मार्क पब्लिश हुआ 8 जनवरी 2019 को. बट हमारा जो रिजेक्शन ऑर्डर सर जो है वो पॉइंट नंबर 15 है सर. किस ग्राउंड पे हमको अपॉइंटमेंट कंसीडर नहीं किया गया सर. सर रिगार्डिंग इंस्ट्रक्शन बाय OFB वाइड लेटर नंबर so and so dated so and so, please note that the same was further clarified Ordnance Factory Board Kolkata wide letter number so and so dated 17/10/2013 that the executive qualification should be mentioned as matriculation plus NAC/NCT NCVT without mentioning failing which clause in exacting SRO. The above letter are available in public domain. Sir, executive instruction page number 320 annexure A/20 sir.
17/10/2013.
जी सर.
NAC and NTC are to be treated at par.
सर ये 322 में annexure 20 है सर. 322 में तो सर इसमें लिखा हुआ है कि इन कंटिन्यूएशन of OFB circular number so and so dated it has intimated that in the advertisement for direct recruitment to semi-skilled post of annexure A trade the request qualification should be mentioned as matriculation NAC/NCT NTC issued by NCT without mentioning failing which clause as exacting SRO. Sir, Right to Information Act annexure 21 page 323 next page sir. सर उसमें हमने पहला क्वेश्चन पूछा था इनसे कि श्रीमान डेंजर बिल्डिंग वर्कर पद का गैजेट नोटिफिकेशन, तो उस गैजेट का नोटिफिकेशन का मूल योग्यता और उस चयन का योग्यता अर्हता एवं मूल योग्यताएं क्या हैं, इसके बारे में प्रार्थी को जानकारी उपलब्ध कराएं. तो सर इन्होंने रिप्लाई में दिया कि प्लीज रेफर SRO 184/94 सर. तो एनेक्चर A/19 नंबर 309 सर, द गैजेट नोटिफिकेशन सर. सर कंटिन्यू करें सर.
Yes, yes.
सर SRO द गैजेट नोटिफिकेशन ऑफ इंडिया सर. SRO पावर सर आर्टिकल 309 से है. विदाउट पार्लियामेंट्री एक्सरसाइज एक भी क्लॉज सर इसका डिलीट नहीं कर सकते सर. सर फैक्ट क्वालिफिकेशन सर पेज नंबर 315 315 पेज सर.
Yes.
सर नेम ऑफ द पोस्ट सेमी स्किल्ड वर्कमैन सर. सर पॉइंट नंबर 8 नेक्स्ट पेज. सर educational and other qualification required for direct recruitment for the trade at annexure A, National Council of Trade for vocational training certificate in the relevant trade failing which by ITI or equivalent diploma certificate. Sir, executive instruction without mentioning failing which clause but gazette notification in the relevant trade failing which ITI. Sir, this is a principal clause. Without parliamentary exercise, no change I of law, sir. इसको without parliamentary exercise नहीं काट सकते, sir.
Right.
Sir, page number 320, note 10, sir. Sir, in relation to prescribed qualification under column 8 of this schedule, the question whether a qualification is equivalent to prescribed qualification for post shall be decided by the Ordnance Factory Board. Sir, Ordnance Factory Board को Article 309 में only equivalency decide करने का power था. इन्होंने failing which ITI जो principal clause था उसको delete कर. सर, ट्रिब्यूनल का जजमेंट है सर, पेज नंबर 301, 301 पेज नंबर, पॉइंट नंबर 8 सर.
Yes.
The main thrust of the applicant is that the post of danger belong to semi-skilled to skilled, and as per the recruitment rules framed Article 309 of the Constitution of India, SRO 185 of 94, the essential qualification for the post is question is NCVT certificate in the relevant trade failing which ITI candidate having ITI or equivalent diploma certificate considered. There is no reduction for consideration of the candidature of a candidate having no NTC, NSC candidate, since advertisement has been issued given condition stipulated in SRO 185, Ordnance Factory Group C and Group D Industrial Post Recruitment Rules 1994. The candidature of the applicants ought not to have rejected on the ground of lack of essential qualification. It has been contended that the authorities failed to appreciate the law that an executive instruction cannot override the statute provision. The SRO 17/10/2013 executive instruction without mentioning failing which clause issued by Ministry of Defense Ordnance Factory Board is an executive instruction, and the said executive instruction cannot override the statutory provision provided under Ordnance Factory Group C and Group D Industrial Post Recruitment Rules 1994 issued under Article 309 of the Constitution of the India, and therefore the rejection of the candidature of applicant is not sustainable in the eye of law. By drawing our attention to the information right under the RTI 2005 कि एडवर्टाइजमेंट का और बेसिक क्वालिफिकेशन का गैजेट नोटिफिकेशन SRO 185 से हुआ है, placed at annexure A by 16, it has been content that rejection of candidature of the applicant based on the condition stipulated in the executive instruction under annexure A by 15 dated 17/10/2013 is not suitable. The sum and substance the case of the applicant is that in the rule SRO 185 the essential qualification for the post of DBW is provided as National Council of Trade for vocational training certificate in the relevant trade which failing which by ITI or equivalent diploma holder, where in the advertisement it was mentioned National Council of Trade for vocational training certificate, which is contrary to rule. It has been stated that although the applicant are having the qualification as provided in the SRO 185 and more than cutoff mark in the selection, respondent rejected their case on the ground of lacking essential qualification and appointment private respondent, which is bad in law. In supported in their claim, they have placed reliance on the decision rendered by the Bombay bench of tribunal similar OA number 404 of 2012 डिस्पोज ऑफ सो एंड सो इंदिरा पदार्थ. सर बॉम्बे केस में और इस केस में एक बात सर जो डिफरेंट है, बॉम्बे केस में मार्क सर पब्लिश नहीं हुआ था। प्राइम मिनिस्टर का सर प्राइम मिनिस्टर ऑफिस का सर इसमें कॉपी एनेक्चर है। प्राइम मिनिस्टर ऑफिस के डायरेक्शन पर कट ऑफ मार्क फाइनल सिलेक्ट लिस्ट आफ्टर 6 मंथ पब्लिश किया गया था, जब कंडीशंस डॉक्यूमेंट कैंडिडेट का पुलिस वेरिफिकेशन एंड अपॉइंटमेंट इशू होने लगे थे। तो कट ऑफ मार्क्स सर बाद में पब्लिश होने थे, हमको बाद में मालूम पड़ा कि हम मेरिट में सर। लास्ट पेज सर इसका जो है पैरा 18 है, पेज नंबर 307 सर। Further, the fact it appears that the applicant were very much vigilant about rule etc. Even then they appeared in the process of selection with the exacting condition stipulated in the advertisement. When he could not be selected due to lack of essential qualification, the applicant challenged the condition made the advertisement, which is not permissible in law. It is also seen that no prayer has been made for questioning the condition stipulated in the advertisement. It is also seen that in the order of rejection, the respondent have deleted into all the submission of the applicant, leaving no scope for the tribunal interpretation. सर जो द लेटेस्ट जो प्रोविजन ऑफ लॉ सर है डॉक्टर मेजर मीता सा है, तो सर उसका पैरा 18 जो है कह रहा है कि हाउ यूर वी मस्ट डिफरेंशिएट फ्रॉम द प्रिंसिपल इंसो फॉर एज द कैंडिडेट बाय एग्रीइंग टू पार्टिसिपेट इन द सिलेक्शन प्रोसेस only accept the prescribed the procedure and not the illegality made by the commission. In a situation where a candidate alleges misconstruction of statutory rules and discriminating consequence arising therefrom, the same cannot be condoned merely because a candidate has partaken in it. The constitutional scheme is sacrosanct and its violation in any manner is impermissible. In fact, a candidate may not have locus to assign the incurable illegality or derogation of the provision of the Constitution unless he participates in the selection process.
My lord, whatever factual side he's submitted, I don't have any dispute over those things. The case was, advertisement was floated, he participated. Thereafter, he filed an original application saying that by issuing an executive instruction, you cannot override the statutory provisions. That is relying on that only. He preferred the case in the tribunal. Tribunal passed an order that has been challenged in the writ petition. Whatever judgments he has submitted, there cannot be propositions. Only thing, my lord, the Honorable Supreme Court may read.
Kindly give him a copy.
I'm giving. Para 7, man. The appointing authority is competent to fix a higher score for selection than the one required to be attended for mere eligibility. But by way of its natural corollary, it cannot be taken to mean that eligibility oblique norms fixed by the statute or rules can be relaxed for the purpose of, to the extent that the same may be lower than the ones fixed in the statute. My submission is, my lord, your lordship may kindly come to page 309. Relevant portion is at page 316.
Yes.
316 clause 8. Educational and other qualification required for direct recruits. For the trades at Annexure A, National Council of Trades or vocational training certificate in the relevant trade, failing which by ITI or equivalent diploma certificate holder. This failing which clause has been taken away at page 320. Your lordship may kindly see page, 322. 322, my lord. That's what my learned friend says, that this is an executive instruction which cannot override. Here it says, my lord, may I read, my lord. In continuation of OFBA circular dated so and so, it is hereby intimated that in the advertisement for direct recruitment to semi-skilled posts in Annexure A trades, the requisite educational qualification should be mentioned as matriculation plus NAC, NTC issued by NCB without mentioning the filing which clause in the existing SRO. SRO of which I was placing my lord, that carried the word filing which clause. That has been decided by the authority concerned not to impose that filing which clause. What my submission is, my lord, this is a not a relaxation. Honorable Supreme Court says you cannot relax a qualification by issuing any executive instruction. This is no relaxation. Rather, it has become made a little bit more stringent. May I read once again that para 7 of that Honorable Supreme Court's observation?
Yes.
The appointing authority is competent to fix a higher score for selection than the one required to be attended for mere eligibility. But by way of its natural corollary, it cannot be taken to mean that eligibility norms fixed by the statute or rules can be relaxed for the purpose to the extent that the same may be lower than the ones fixed by the statute. My submission is, by doing away with this filing which clause, it has not been relaxed. Qualification has not been relaxed. Rather, it has been made a more stringent. That apart, my lord, he participated in the recruitment process and thereafter he has challenged. Your lordship knows,
for that he has quoted this last judgment saying if it is an illegality, he can still.
I cannot have any dispute over that proposition. This is the small point to be adjudicated in this case as to whether executive instruction, is it a executive instruction which are overridden the statutory provision, or it is a higher norm prescribed by the authority concerned for the purpose of selection. That is why from the beginning I was saying, if your lordship permits me, I can say that factually there is no dispute. But this is the only question of law.
All right. और कुछ कहना है आपको?
सर हमको यही कहना था कि राइट टू इंफॉर्मेशन में हमको जानकारी दिया गया कि डेंजर बिल्डिंग वर्कर पद का गैजेट नोटिफिकेशन और उसका मूल योग्यता का गैजेट नोटिफिकेशन SRO 185 से हुआ है। ये बात डिपार्टमेंट ने बोली। आफ्टर 6 मंथ कट ऑफ लिस्ट पब्लिश किया। कट ऑफ लिस्ट उसके साथ साथ आता है सर। कट ऑफ लिस्ट पब्लिश नहीं किया। आफ्टर प्राइम PMO के इन्वॉल्व पर होने पर सर जो है एनेक्चर ए बाई प्राइम मिनिस्टर ऑर्डर का सर कॉपी लगा हुआ है जो है एनेक्चर 8 में जो है सर प्राइम मिनिस्टर ऑफिस का सर कॉपी लगा हुआ तब कट मार्क पब्लिश किया गया सर। जब राइट टू इंफॉर्मेशन एक्ट में SRO को क्लियर कर दिया गया सर, failing which ITI criteria not a equivalency. This is a principal clause. Without parliamentary exercise, no change of law, sir. Without parliamentary and except to procedure, not an illegality.
All right. Order is reserved.
Supplementary list item number 65.
Lordship, item 65, my lord. Lordship, I am appealing to virtual mode for the petitioner in the second tax matter, my lord. That is writ petition 32208 of 2021.
First matter, I have not received counter, Lordship. WPC 13992 of 2022. Counter not received.
My lord.
All right.
Lordship.
Yes, please.
Lordship, in the second one, we need to file a rejoinder, my lord. So I
right. 13992 of 2022, counter be filed within 4 weeks, rejoinder for the next date. In 32208, rejoinder be filed for the next date.
Lordship, in 32208, interim order to continue, my lord.
Yeah, in the second one, interim order.
First one also interim order there, Lordship.
Or both matters, interim orders to continue.
We are appearing for the owner.
Item number 66.
1 minute, one date here, not sorry. 14th March.
Item number 66.
Yes, sir. Please make your submissions. Mr. Mishra, please make your submission.
My lord, in this case, my lord, last officer Lordship will direct the status report. Status report is submitted. In the meantime, my lord, the manager, the video status was submitted, and also the counter affidavit filed by the Tahsildar manager. But the both are contrary to each other. The status report, the legal errors are reflected in the last para. But in the counter affidavit filed by the Tahsildar, it is absolutely different. There is no link with the petitioner plot. My petitioner, when the land is grabbed and he was helpless and submitted his grievance before collector and Tahsildar, thereafter for the end of his life, he submitted the application of the President of India. Thereafter, my lord, this case was registered. In the meantime, to escape the allegation made by the petitioner, the affidavit is filed, my lord. If ROR is changed, then there must be the legal error of the tenant, nothing else.
But all the 4 persons named in the news article have died, sir, now. Have you seen the...
Yes, my lord. My lord, they live...
What more needs to be done, sir?
Status for para 4, my lord. Those are LF, they are clearly reflected. Para 4, last.
Come to para 4 of the counter affidavit filed by the Tahsildar, sir.
Yes, my lord. May I read, my lord?
Yes.
That is respectively submitted that the plot number 206 of the Muja, Paramarpur, the steel is exist as the full plot and has not been fragmented. And it is the pertinent to mention here that though the beneficiary mentioned above were the granted with the ceiling surplus land, yet that during the settlement operation, it was the duty of those persons to get the land and recorded in their favor after obtaining the necessary permission from the consolidation authorities. Having not done so, the beneficiary fell to the statutory obligation to get the ROR and corrected in their favor. And as such, while Tahsildar has no role to play in this regard, it is pertinent to mention that the beneficiaries having failed to their attempt to get their ROR.
What is your submission, sir, on that? What is your submission?
My submission is that when the person is helpless and he has left the place.
No. So can the District Legal Services Authority can help them?
Yes, my lord.
Oh, that's all right. You say the para 4 of the counter affidavit filed by the Tahsildar reads as under reproduce para 4. Paragraph. There is a separate report submitted by the District Legal Services Authority, Sambalpur, enclosing the report of the BDO Maneshwar to the effect that all 4 persons named in the news article, on the basis of which the present present petition was registered, have in the meanwhile expired. So the report sets out the names of all the legal representatives of the said 4 persons. Paragraph. A direction is issued to the DLSA Sambalpur to assist the said LRs of the 4 persons to have the ROR recorded in respect of the
That is reflected para 3 last portion.
To take appropriate steps for correction.
For recording of the ROR, to assist them in approaching the authorities concerned for registering the ROR in their names.
In accordance with law.
In accordance with law. Full stop. No further directions are called for at this stage. The petition is disposed of.
Item number 67.
In this case, my lord, I was to affidavit because there was an old affidavit, new affidavit, status report, your lordship. I need.
I'm appearing for the Central Pollution Control Board, my lord.
Yes.
Is that
Central Pollution Control Board, I'm appearing, lordship, in this matter. Order number 7.
That is what I am saying.
Order number 7 was there.
Time to file count.
Yes.
Affidavit.
I am appearing for the Central Groundwater Commission.
Mr. Monty seeks some more time to file an affidavit in terms of the
order dated
23rd August 2022. The affidavit positively be filed on or before 19th December 2022. List on 2nd January.
Item number 68.
May I please your lordship, my lord, item 68. This is a public interest litigation, my lord. The petitioner seeks for a direction to the opposite parties for proper maintenance of the playground and the parks, my lord, public parks. Last time your lordship directed to file an affidavit.
Mr. Nayak was to take instructions.
Yes.
What are your instructions?
I'll seek some more time, my lord. I haven't gone to the instructions. So 1 week's time.
Mr. Devashish Nayak, learned counsel CMC, seeks some more time for instructions in relation to the park in question. Current status of the park in question. Okay. Park and playground in question. List on 3rd January.
Okay. Item number 69.
69 pursuant to last order, I have already filed the compliance affidavit as well as the pen drive.
Just play the pen drive. Pen drive is there.
So this can we have it? They were all given us just yesterday. Everything
we received yesterday.
Oh, I see.
A short date, if my lords can just.
My lords, we have not received the affidavit, and my lords,
Please.
my lords, we have not received the affidavit. But my lords, I am seeking a small indulgence at this juncture.
Yes.
Because my lords, I have a very limited prayer when I have filed my intervention application. My lords, I am seeking that the paramedicals which are still vacant, they should be filled. So my lords, I will just show 2 documents.
Yes.
And I am seeking, my lords, that if indulgence of this honorable court, because amicus have been appointed,
yes,
that if they may file some status report as to what steps have been taken or whether the budgetary provisions are there. My lords, may kindly come to page 18 for a minute of my application. Page 18, annexure 2. And my lords, I will not bother much this honorable court. My lords, I will just show my lords that since 1981 up to 2002, the leprosy detection rate was hardly 20%. My lords, got it? Page 18.
1 minute. What's the IA number?
This is my lords, Satyanarayan Kushti Seva Samiti application, page 18.
The IA number was 6754.
6754.
Just take it down.
Flag 24.
Right.
My lords, got it? Page 18.
18. Yes.
Yes, my lords. It is annexure 2, my lords.
Correct.
Now, my lords, will see from 1881 onwards, we have given all the data.
Correct.
And this is the data of National Leprosy Eradication Program data, my lords.
Right.
So this data says that since 1981 up to 2002,
correct,
my lords, the leprosy detection rate was hardly 20%.
Right.
Now, my lords may see from 2002-3 onwards, it rises, my lords, from 30% and it goes up to 47 to 49%.
Right.
Now, my lords, now this is the scenario which continues till date. Now, my lords, may kindly come to annexure 3, which is at page 20. And my lords, got
yes,
page 20. My lords, in this, the government has admitted that out of 403 paramedical workers, 310 vacancies were 310 posts were vacant in the year 2012.
Correct.
And my lords, the same position continues till date.
Right.
I have mentioned in my application. So, my lords, what I am submitting,
yes,
that since a MICAS has been appointed,
yes,
my lords, they should file some status report.
Yes.
Because, my lords, the persons affected with leprosy are suffering
correct
on regular basis. And it is the data of government itself that the leprosy is rising on, my lords, rising. Correct. So, my lords, if they may file some report and we may be, my lords, and this application may be adjudicated upon, my lords, and I shall be
This was recorded by order number 29. This submission of Mr. Sinha was recorded.
Right.
In fact, the counsel for the government, he can apprise the court.
Well, in
para number 1, order dated 18/5/2022. So I think Mr. Mudali, he can apprise the court as to, there was an earlier direction of this court.
Correct. So, MICAS file an independent report, and my lords,
I have filed the reply. Your Lordship can see, probably that is available at flag 25. That is affidavit on behalf of the Additional Chief Secretary, Health Department, affidavit dated 1/8/2022. This is signed by Dr. Ajit Kumar Mahanti. Man, let's got it.
Yes.
On internal page 3.
Yes.
Paragraph 4.
The subcommittee will prepare in place for a larger committee.
No, my lord.
Oh, that one.
Page 3, that after integration of NLEP program with the general healthcare system, the post of paramedical worker have been abolished by government order number so-and-so, which was informed to the SSCPD department by letter number so-and-so dated 14/9/2021. At present, the leprosy work is being carried out by the general healthcare staffs like medical officers, IUs, medical officers, physiotherapists, multi-purpose health worker, as is implemented for other programs.
No. Which paragraph? Para 4.
Para 4. I am placing the affidavit dated 1/8/2022, signed by Dr. Ajit Kumar Mahanti.
Oh, 1 minute. That's not flag 25, sir.
I am sorry. Ma'am. Sir, flag 36, madam. Flag 36. Internal page 3, paragraph 4.
This is not that. No. This is
Which noting shows that affidavit.
Ajit Mohanty. The deponent is Ajit Mohanty.
Yes.
That is
it's dated 1/8/2022.
No. Date is 1/8/2022.
That is it.
The cause list noting is that affidavit pursuant to order dated 18/5/2022 filed on behalf of the Commissioner from Secretary to Government of Orissa is at flag 36.
Here is it. All right.
1915.
No. He's referring to a affidavit of 10/8 or something, correct?
Page 3.
No. What's the date of the affidavit?
1/8.
1/8.
If my lords permit, I can pass on my copy, my lord.
My lords, we have also not been supplied, so I don't know whether it is on record or not. But anyway, since my learned friend was making submission, so I thought I should not interject. Even I had word with my learned friend, he has also not been supplied. So I don't
No, but the point remains, Mr. Mudali, how does one cater to this large population of affected persons?
No, they are being treated by the general healthcare staffs.
No. Are they enough number? See, the whole thing is about how many people you need for treatment.
That data that is not there, I'll file.
You better file it.
We are saying that 403 is the sanctioned post.
No. Apparently, those posts have all been abolished now.
Yes.
That's
No,
what I have to say.
No, my lords. May I just say, my lords, in 2002, there was a meeting of high-powered committee. We have annexed, my lords. So there were 2,137 posts, out of which 1,251 posts were kept for these.
Mr. Sinha, we are now in 2022.
Yes, my lord.
2022.
Yes, my lords.
He now is referring to an affidavit of 1st August 2022, which you have not seen.
My lord is absolutely correct.
So in that affidavit, he apparently has averred that these posts have been abolished.
Yes.
So you better exit affidavit. He will file. He says instead of paramedical workers, they're engaging the existing regular staff for treating people, and he says he will provide statistics of how many such people are available.
My lord, he is saying general health worker. I am saying, my lord, those posts have not been abolished, and these are leprosy trained paramedical workers who have been basically kept out of
Mr.
those.
Sinha, I suggest you see the affidavit. We'll ask him to provide you a copy.
As my lord's wishes.
Where is our?
Please,
okay, it's flag 36. Flag 35 is there. 36 is not there. Dr. Ajit Mohanty, please. 1/8/2022. This is flag 35, which you are showing me. On 8/22. For us is a different affidavit. One Dr. Madhumita Naik. That is only marked 30. It was filed on 2nd August. Maybe this is not filed.
No, it hasn't filed. No. My heading shows that affidavit filed on behalf of the Principal Secretary to Government, Odisha, in charge Health and Family Welfare. That is also the noting.
Can you show us a copy of the affidavit? Flag 40. It is flag 40, sir. Flags. Where is it? Flag 40. 39. 40. Yes.
Paragraph 4. Internal page 3.
No, there are no 4 paragraphs. No. No, this is some 6/9/2022. This flag 40 is also 6/9/2022. I think we'll have to get another copy of that 1/8/2022. You're not able to get it. All right. just this IA number. In the order dated IA 16754 of 2022. Pursuant to the order dated 18/5/2022, an affidavit has been filed by Dr. Ajit Manthi, Principal Secretary to the Government Health and Family Welfare Department, Government of Odisha, on 1st August 2022, inter alia stating in para 4 that after the integration of the NLEP program with the general healthcare system, the posts of paramedical workers, bracket PMWs, have been abolished by a government order dated 22nd November 2001, which was informed to the SS and EPD department on 14th September 2021. And that, open quotation, at present, the leprosy work is being carried out by the general healthcare staff like medical officers, Ayush, MOs, physiotherapist, multi-purpose worker, bracket MPHW, ASHA, as is implemented for other programs, unquote. Paragraph. Copy of the said affidavit is, however, not available in the court record and has also not been served to counsel for the applicant in the present application, Mr. Pankaj Sinha, who appears along with Ms. Sevati Soren and Mrs. Rekha Sinha, advocate.
No, Mr. Rekha is not there.
All right, all right.
She is not CWC member.
All right. Sevati Soren, full stop. Mr. Mudali states that he will arrange to have a copy of the said affidavit served on them today itself. A copy be also served to the learned amicus curiae. Paragraph. Mr. Mudali undertakes to file a further affidavit indicating, disclosing the number of multi-purpose health workers who are available for treating persons affected with leprosy, which numbers have been increasing steadily, as is evident from the Annexure 2 to the present IA 6754 of 2022. The affidavit will be filed at least, the further affidavit will be filed at least 1 week prior to the next date, with an advance copy to counsel for the applicant and the amicus curiae.
But also copy be served upon us, for open.
And everyone else who wants it. All right. And everyone else who wants it. All right.
Yes,
okay. Paragraph. In the main writ petition, you say, pursuant to the order passed on 24th September 2022, affidavits have been filed on 10th November and 14th November 2022, enclosing pen drives containing photos and videos of the colonies visited by various teams. The learned amicus curiae states that he has received copies of these affidavits and the videos only yesterday and needs some time to examine them and make submissions. Full stop.
Short date.
We'll have it on the 3rd or 2nd, whichever is convenient.
As
1 minute. There's already something else, is it? Yeah.
In the month of December.
December, almost every day we have some other PIL.
Just that we have served yesterday, we couldn't coordinate amongst us.
So you take a chance on 8th December then. Let me see how many matters are there in 8th. Okay. 8 December.
8 December.
All right.
We are great.
All right. 8 December.
Great.
All right.
States can it be 7th? 7th only.
All right. 7th December. All right. All right.
There are small matters. If
Correct. No, we'll finish the board. And
yes, ma'am. Obliged.
Supplementary list item number 70.
Item number 70, I have an online mode. So first matter, I is time to file a rejoin application counter filed by the state.
7.
Registration of interest at panchayat level.
Sorry?
That is in WPC 15380, perhaps. Mr. Dikdas? 15380. Yes. In other case, we will file affidavit.
May I submit? Please. My lord. This the first lead case 22528 of 2015 was due to an incident that was published in the Hindu newspaper, where the palms of 2 migrant laborers were chopped off. That is what led the Supreme Court to come out with directions that were given to various state governments to comply. Odisha specifically, and that's how our High Court has taken up the matter. Right. In that context, there was a counter affidavit filed in the on 15/4/2019. Right. And then after that, there was an affidavit filed on 3/1/2020. This 3/1/2020 affidavit details an annual activity plan for the year 2019-20. That has now become obsolete. It's gone. What we want and what perhaps the court would like to see is what is the activity that is planned subsequently, and whatever activity plan was there, what was the accent of the activity plan? Because that was only a plan. In the meantime, COVID came. So the status they have to update. And the 2019 affidavit, detailed counter affidavit, I'll just point my lords to page 330 of that affidavit, which contains measures to obliterate migration of laborers. Right. So 330 has a lot of details about what the state is supposed to do. So let them file an affidavit. Yes. So what have they actually done with statistics? That's what we need to make an assessment.
My lords, in the next case, my lord, they have filed a counter, and thereafter I had filed a note on submission, my lord. I'm appearing in person, my lord.
Correct.
And thereafter, my lord, the central government has also come up with their counter.
Correct.
My lord, basically, I feel that the migrant laborers who have gone out of our state are covered by Interstate Migratory Act of 1979.
All right.
The other category is migrant laborers who have come into our state. They will be covered by Unorganized Workers Social Security Act of 2008, my lords. So in the context of the counter, my lord, given state, I have one grievance, as it were, is that in the counter, the definition of unorganized worker in section 2M say includes a wage worker is such and such and such as plus migrant worker. They have filed in the counter in page 23 of the counter, where they have said that they have not covered the word migrant in the rules. So that needs to be corrected, unless it's an inadvertent mistake in the counter that they've not mentioned the migrant worker as part of the unorganized workers rules made by the state government. That is one point, my lord. Second is the counter filed by the central government is all about, we have this yojana, we have that yojana, we have this scheme, but not a whisper about how it has been implemented.
Is it possible for you to find even the names of 20 migrant workers who have not benefited by all these schemes? Then we can have definite directions issued saying, despite all your claims, so many people have not benefited. Then we can they can test the implementation. Test implementation is to actually pick up examples of people who've been migrant workers and have not benefited.
Yes, my lord. I'll try. That's difficult.
That's the only way.
Yeah.
Otherwise, what will happen is we won't mind. You'll get a judgment, you'll get orders.
Yes.
Nothing will change on the ground.
My lords, initially in their first counter, they had said that the migrant workers who have come back to the state is around 1 lakh odd. Then the Supreme Court, in an order, so motor petition, Supreme Court said, don't go by the numbers were registered by the Interstate Migratory Act. Go by numbers who have come back to the state. pursuant to my note and submission, the state government came up to say, no, it's not 1 lakh odd, it is 10 lakhs odd. So they are aware of which migrant laborer of which district has come back to which district. So they have the figures with them. My lord, third and the last point is that the same Supreme Court judgment, which I was relying on in my note and submission, has reached its finality. There's a very exhaustive judgment on that matter. I have given the copies of the judgment, my lord. So it's 80 pages of detailed how migrant laborers, what is to be done with them, what
since there is such a detailed judgment, you still want us to give a judgment?
No, my lords. I rely totally on this, except the anomaly about...
Can we dispose it off in terms of this judgment?
Yes, my lords.
All right.
And also that anomaly about the migrant laborer, the word should figure in the rules. They have not mentioned, they have not gone as per the definition of the Act. Page 23 there. My lord, page 23 of the counter.
1 minute. Internal page 23, is it?
No, my lord, they are page 20. Counter page 23. No.
Annexure D by 3.
Right.
Yes, my lord.
The gazetted rules.
Yes, my lord. Para 7, my lords.
The workers such as street vendors.
Yes, ma'am. Street vendors, small traders, domestic workers, rickshaw pullers, auto drivers, cobblers, agriculture and forest workers, newspaper hawkers, scavengers, working in unorganized sector shall be registered. Unfortunately, the word migrant has slipped, but it says so in the Act, my lord, in definition 2N of Unorganized Workers Act. They've made it more exhaustive than the definition there, but certainly missed out on the word migrant. The definition in that Act talks about wage worker means a person so and so.
Where is that Act? Here. 1 minute.
I've also quoted in my petition.
This is the Orissa Unorganized Workers Security rules.
Yes. Page 10. I've quoted in my petition, page 10. Petition.
Definition is 2. They've got the Act.
2, small n. N for Nagpur.
Wage worker.
Wage worker means a person employed for remuneration in the
or as a migrant worker.
Yes.
Right.
So that is the only anomaly I see. And if the central government would come back on figures, that will be part of your order, my lord, to say exactly how many have benefited instead of just talking about. In fact, this Supreme Court judge also says that central government keeps talking about yojana schemes, but not mentioning as to how many have benefited pursuant to those yojana schemes, how much fund has been spent, who has benefited.
No, so are you suggesting we keep this pending or dispose it off or
no,
what?
My lord. My lords can dispose it off on the basis of this judgment. But however, if your lordship wishes, it could be a continuous mandamus, at least to
because
see
there are
the
anyway
figures.
2 other connected petitions. You see the other 2 where Mr. Nayak has been appointed as amicus.
Yes.
That anyway we'll have to proceed with.
So specifically, if they can come back on figures, the central government. And if this anomaly could be corrected in the meantime.
All right. What about 2678? What is that about?
My lord, I'm appearing in virtual mode. My lord, I'm appearing in virtual mode. I seek time to file the rejoinder. I have received the counter filed by the state.
No, are you aware of the Supreme Court judgment?
My lord.
No.
My prayer in the writ application is provide registration of migrant laborers at panchayat level.
Sorry?
Problem being at the district.
You're not very clear.
My PIL is relating to registration of migrant labor at panchayat levels. not at the district level. At present, the state government is providing registration from migrant level at district level.
All right, let's take the first 15380. We'll clarify that that will include migrant labor.
Yes,
because-
ma'am. Yes.
The petitioner who appears in person has placed before the court a copy of the judgment dated, or copy of the exhaustive judgment dated 29 June 2021, passed by the Supreme Court of India in suo motu writ petition civil number 6 of 2020, bracket, in re problems and miseries of migrant laborers, bracket. Stop. She states that many of the issues raised in the present petition stand answered by the aforementioned judgment of the Supreme Court. Full stop. Paragraph. She, however, draws attention to the Odisha Unorganized Workers Social Security bracket Amendment Rules 2019, which seeks to amend the Odisha Unorganized Workers Social Security Rules 2010, which in turn has been made in terms of Section 14 of the Unorganized Workers Social Security Act 2008, bracket Act, and submits that in Rule 5, bracket 7 of the amendment rules, which seeks to amend, in Rule 5 of the amendment rules, which seeks to amend Rule 13 of the 2010 rules. In Rule 3, the single quotes migrant workmen, the migrant worker, sorry, has somehow been omitted. Paragraph. Rule 13, bracket 7 of the 2010 rules as amended in 2019 provides for registration of single quotes beneficiaries and for generally workers to be registered by the state board in the first phase. Under Rule 13, bracket 7, there are several categories of single quotes workers which have been mentioned. But for some reason, single quotes migrant worker, unquote, is not mentioned. Under Section 2, bracket N of the Act, a single quotes wage worker, unquote, has been defined to mean, has been defined as under, and then reproduced to N. Paragraph. Since the rules have to be consistent with the Act, it is obvious that the reference to single quotes workers in Rule 13, bracket 7 of the 2000 rules as amended in 2019 would include single quotes migrant worker. Stop. It is accordingly clarified. We'll stop. The state government will consistent with this declaration, either further amend the 2010 rules or issue a notification. No, further amend the 2010 rules to reflect this change. Stop. Paragraph. The writ petition is disposed of in terms of the judgment of the Supreme Court referred to above. Then in the first writ petition 22528 of 2015, this PIL had been registered suo motu by this court on the basis of news item No, I think this was registered because of the Supreme Court's direction.
My lord, the first of the counter affidavit dated 15/4/2019, para 2 has the details.
Actually, on the basis, no, you see, the genesis of the present petition was a news item carried in the Hindu in its issue dated 3rd January 2014 about an incident involving the chopping of the palms of 2 migrant workers in the state of Odisha. So on this basis, the Supreme Court of India registered a suo motu writ petition, civil number 30 of 2014. Stop. Meanwhile, another WP civil number 55 of 2014, raising a similar issue, was filed in the Supreme Court, seeking redress against exploitation of migrant workers in Odisha, filed by Sri Radhesham Jaina. Good stop. Under directions of the Supreme Court, both petitions to transfer to the High Courts of Orissa and Andhra Pradesh with a request to register a public interest litigation, bracket PIL. On that basis, the present petition was registered and an order was passed on 15th March 2019 calling for affidavits. Full stop. Pursuant thereto, full stop. It may also be noted here that on 16/12/2019, this court appointed Mr. Debashish Naik, learned counsel, as amicus curiae, bracket AC in this case. Paragraph. A counter affidavit was filed on 15th April 2019 by the state government, setting out the action taken place by it and enclosing a single quote state action plan for the safety and welfare of interstate migrant workmen, unquote. Paragraph. There have been other affidavits also, Mr. Naik.
This surveys primarily Of the 6 districts that are affected.
No, 2014. 26 February 2014. Oh, this was filed at the Supreme Court, is it? Must be, this is the copy of the affidavit filed in the Supreme Court. Correct. Sorry. All of this filed in the Supreme Court. The entire paper book of the Supreme Court has been sent here. Right. Thereafter, no further affidavit has been filed by the state of Orissa in this court. Correct. It is directed that the state government will file a further updated affidavit giving details of the number of beneficiaries whose grievances have been redressed under the state action plan year-wise. And how the state action plan has helped in redressing many of the problems noticed. Many of the problems highlighted in the various reports filed in the Supreme Court of India in the aforementioned petitions. The court also calls for an affidavit from the Union of India to inform the court about the steps taken under its action plan. What is the plan of the central government? What is it called?
Yes, my lord.
The central government's plan.
It is called PMGKY, Pradhan Mantri Garib Kalyan Yojana.
Under the Pradhan Mantri Garib Kalyan Yojana. Paragraph. Both affidavits be filed within 6 weeks with advance copy to the learned amicus curiae.
My lord, also another scheme is there, PPMOY.
Sorry?
Another scheme also, the Pradhan Mantri Jivan Jyoti Yojana.
As well as the Pradhan Mantri Jivan Jyoti Bima Yojana.
Yeah.
But there's also a Pradhan Mantri Suraksha Bima Yojana.
Yes.
And the Pradhan Mantri Suraksha Bima Yojana. List on. March.
5th March.
My lords, in my case also, your lordship had tagged another case to be heard with my case. It is 116 of 2015 by your lordship's order. It was about a missing worker from Patnagarh.
Where is that? That's not on board today.
That is not on board, but it is the order in that case. Sebati Putta versus State of Orissa.
116.
116 of 2015. It had nothing to do with my case, but your lordship found that there was a complaint of a missing worker. So it was tagged so that the police was supposed to give papers and all. It never happened. I've got a copy of that order.
I think this is a different issue.
Yeah, it was different, but it was tagged. So some order needs to be passed on that.
No, if it is on board, we can pass an order.
No, it is not.
If it's not on board, then we'll have to have it listed.
Since my case is being disposed, I don't know what the future of this.
So that's okay. That matter is still pending, no?
No. That has been disposed of.
That is a separate writ petition, I think.
Separate writ petition.
Separate writ petition. It can be listed tomorrow.
No, this has already been disposed of.
Saying that the papers were to be given from this case. Since
That's
it's
right, but
concerned migrant
since it's already
workers.
been disposed of. This has already been disposed of.
So this also looks after that.
Yeah, this has already been disposed of. Right. In the third petition, you see Mr. Devdas states that he'll file a rejoinder before the next date. And that will also be listed on the same day. Given a date, right? 6th March. 6th March.
6th March, my lord, so
Right.
Well, my item is disposed of.
Correct.
My lord, this 15380 disposed of.
Yes.
Yes, 15380 is disposed of.
University concerned to that case.
If some instructions could be given to central government to follow
I
the
have just
judgment.
done that. In the other connected matter, you heard the dictation.
Sorry.
We've mentioned all the 3 yojanas.
My lord may reflect along with me, Mr. Accept appearing along with me.
All right. All right.
Item 71.
Lordship, item 71, and for the petitioner appearing to virtual mode, my lord. Lordship,
Yes.
Mr. Pitambar Acharya has instruction appearing the matter, but he's on accommodation today.
I see.
My lord, these are the matters which your
Short
lordship used to send it to Lokayukta because he is saying there is some financial irregularities and
Shortage of ornaments of
Pleadings
the
are complete in this matter, and this matter
because
can
it
be
needs a
heard
vigilance
finally.
inquiry also.
Any date
This
can be
type of
fixed, my
allegations.
lord.
And normally your lordship is sending all these matters to Lokayukta for necessary
And
investigation.
second fold of prayer, my lord, that missing of key, that is already sub judice and decided by the
Lordship, short
commissioner
date may
and
be
is
fixed,
now
my lord.
pending
Any
before the
day.
state for notification. So
Lordship, any
nothing.
day may be fixed for its final hearing, my lord.
Final judgment.
All right. Mr. Pidambar Acharya and senior counsel. Is stated to be in some personal difficulty today. And an adjournment is sought. (14th March).
Obliged, my lord.
Item number 72.
May it please your lordships, on behalf of Mr. Mahanti, I am appearing for the petitioners. My lords, we are yet to file the rejoinder and need grant some more time to file the rejoinder.
All right. Rejoinder before the next day. 15th March.
Item 73.
Item 73 is time to file rejoinder. I have received the counter.
Rejoinder
by
be
the
filed.
state.
Item 74.
May it please your lordships. Latterly, the opposite party number 10 filed additional affidavit, your lordship. And we received that additional affidavit yesterday, your lordship.
Your lordships, that additional affidavit is nothing just to show that this person is actually the PI litigant, was somebody who was working under OP number 9 against whom he's made all those allegations. And we had filed it the earlier date also, that how his tripper was actually engaged by us. And we had to discontinue because he did not have some permit. And after that, he's come and filed these litigations. Your lordship, earlier also he was there before you in form of 2 litigations. And he has hidden the fact that similar applications he's been filing. And in fact, the declaration portion, he said that your lordships had granted him permission to file another writ, which on the face of the last order is false. Because your lordships had considered there are so many issues you have raised. The lordship said, you go and you continue it before the appropriate forum. And he files a CMAPL thereafter, after withdrawing. That is also dismissed. So your lordships, in fact, all the allegations that he has made, that, Rule 37 is not followed and blah, blah, all the allegations. And he says that, Shah Commission had gone into it. So all those matters now have been settled by Supreme Court in the common cause order. And all of us have paid the compensation. And today, your lordships, OP number 9 does not even exist. After 2020, another corporate has come in and has taken the lease. Your lordships, all these things are completely violative of the PIL rules, your lordship, 2010. And I'll show 2 judgments, one from our own court, where unfortunately there was a lawyer of our court, and in fact, on that ground, he was not fined. But the court had really taken serious note of such frivolous application to be dismissed. And in fact, another judgment recently from Jharkhand High Court, same stand in the same 2010 rules the court has taken. You don't disclose that you had a war with me, and you come to the court, You hide the fact that there was a litigation pending since 2016 of the self-same pleadings. You don't, I have a doubt he said that in Supreme Court also, because he's gone to Supreme Court also meanwhile and withdrawn there, and files 2 litigation. And last one that he filed, there also in the present one, he makes a false declaration. And he also says all these things, at least when it comes to PIL, because PIL is a very, I mean, it's a jurisdiction which has a lot of sanctity. I cannot see that he would. Your Lordship will kindly take up that miscase at least.
May I submit, Your Lordships? For that reason, they filed one IA application, Your Lordship, seeking for hearing on preliminary point about maintainability of the writ application on the ground of suppression of material fact. And Your Lordship may kindly have a glance at the previous orders. We take notice and we said that we will file the reply to the IA application and rejoinder to the counter filed by the opposite party number 3, 4, 6, and 7. And laterally, they filed one additional affidavit. So we pray for the adjournment, Your Lordship. Recently, we will file the counter.
Your Lordship, just...
Which is his additional affidavit?
Your Lordship, additional affidavit is only I've got the RC of his vehicle on record. That's all I've got on record. RC of his vehicle.
When did he file it?
Your Lordship, no. Your Lordship, that I have given. That's not there.
Yesterday at 4 p.m.
It's not there on the court record. It's not there in the court record. I agree it's not there in the court record. But even if you keep that matter aside...
We'll give a last opportunity to file a reply.
Yes.
Last opportunity in IA 9558 of 2022. Last opportunity to the petitioner to file a reply to this application within 4 weeks. Rejoinder hearing for the next date. Paragraph. The additional affidavit stated to have been filed by the petitioner also be brought on record. (20th March 20).
I've just given the copy and
all right. It's taken on record.
Lordship, can it be a shorter date? Because I'm very sure your Lordship will appreciate it better. That's why.
No, it's all right. 20th March. We have enough work. All right.
We will file positively.
Item 75.
Great.
Petitioner is the Orissa State Power Generation Corporation, my lord.
Right.
The point at issue is, my lord, they are covered by the CASS, my lord. They are also audited by the CG, as statutory auditor. Lord, fifth pay commission, my lord, passed an order regarding enhancement of salaries, and I have to mandatorily also follow it. I made that provision in 2007, 8, 9 assessment year. That, my lord, was disallowed. In that assessment, my lord, was put to scrutiny. 140, it is a 143 order. It was in scrutiny, 143 order, and thereafter, my lord, it was accepted by the learned assessing officer. And thereafter, my lord, it has been reopened on the ground that there are 2-3 aspects, my lord. A, directly contrary, my lord, to Calendar India. B, my lord, directly contrary to Chicken Drive Shaft, because they have not given the reasons for when I asked for. 3, my lord, interestingly, that for the earlier assessment period, and contingent liability like this has been allowed statutorily. And subsequent year also they've allowed it. And therefore...
Consistency, rule of consistency.
Rule of consistency will apply. That is...
Mr. Chimanka. Yes, please.
Lord, here I file the counter affidavit.
But it is covered directly by my lord's judgment also, which my lord has followed everything. The Jagannath one, which...
Where is that?
My lord, that is that. I'll give it. Please, what is this? I mean, a compilation of all the judgments I'm giving to my lord, and the last one is my lord's judgment 2021.
All right. You filed a counter here?
Yes, I filed counter, my lord. I'll reply to this.
I just want to add one more thing, my lord. My learned friend may not be aware of it. In the meantime, my lord, we went to the tribunal for an assessment here. That also has been allowed in our favor.
Yes.
So that is all. It's long and short.
All right.
This, my lord, I've just given for the purpose of, my lord, all the judgments I've covered.
Right.
And I've also covered my lord's judgment.
Page 74.
Page 74 to
Jagannath
79.
promoters. All right. Yes, you were going to file or you have already
We
filed?
have already filed, sir. I'll point out one thing, Lord.
Where is your counter? It's not here.
I have filed on, Lord, 11/7/2020. You'll also kindly just pass on. Copy these, no? Copy these.
Yes.
Lord, I have the preliminary objection that the assessment order under 148. Lord, so far the issue of the reason for communication, Lord, see, he is admitted, Lord, page 6 of the application, Lord.
Page 6 of?
The writ application, Lord. Page 6. The reason for reopening assessment has been communicated via letter number 17 October 2012, which I received dated 20th October 2012 as follows. Communication has been made, Lord, and thereafter 148 order has been passed, and all these points which has been raised as factually, Lord, to be adjudicated, Lord. And your Lordship, now, Lord, after the draft assessment and assessment after the faceless, Lord, I have come across one judgment of the Madras High Court. There, your Lordship failed. Even, Lord, the draft assessment, in spite of you were not communicated in the initial proceeding, then even then, Lord, they say that it should be page 6. The recent judgment of 21/3/2020-22.
No. What does it say?
Here, say, Lord, that there, Lord, in the draft assessment proceeding, Lord, the communication has been reflected. He has not replied to it, Lord. They have challenged the order of assessment. Their Lordship says that it should be returned back because the appellate authorities there, alternate remedies there. Considering the judgment of the GK and Rice, Lord. And GK and Rice, Lord, so far is in this case not complied with because the reason has been communicated. And the issue is, your Lordship, see the order of assessment. This totally factually is not, your Lordship, see. It starts from 103. Sorry, 104, Lordship.
No. In the present case, an assessment order has already been passed.
Yes, my Lord, already passed, my Lord. And now, my Lord, it is all, my Lord, to be examined in the books of account, my Lord. It is a provision. Provision of salary and allowances, my Lord.
Against the impugned assessment order, he has not challenged the assessment order.
Yes, he has challenged the assessment order, Lordship.
He can go in and appeal, you mean?
Yes, that is what my submission.
But this has been pending since 2013 here. That's the only problem.
Your Lordship, therefore, my Lord, I finally counter. It was pending since.
Counter is filed now.
Yes, your Lordship, at your Lordship intervention, Lord.
This is tribunal. Same issue.
Yeah, he says in the subsequent year, the tribunal has already allowed this.
Yes, that has become appellate authority, Lord. Your Lordship, no, Lord, every assessment is different, Lord. I cannot say that.
Previous and subsequent, same issue.
But it is not the issue.
Consistency.
No, Lord, that has to be examined by the appellate authority, Lord.
Why? Why do you address us here?
No,
why
Lord,
send him back? See, after 9 years, why should we send him back?
No, Lord, my Lord, is the other, my Lord, allowed or not? What is the case in that case, my Lord? Is to examine, my Lord.
No, he's already placed one order, I think. You placed your own order.
Yes.
Which one?
This order itself, 143, my Lord, 143.3 was done.
No, 140 is something different.
That is the original assessment.
Yes.
No. You were saying that
subsequent
the earlier year and subsequent
Yes.
year, the same issue has been answered in your favor.
Yes. Yes, judgment. This is the appellate order, my Lord. Tribunal order.
Tribunal has passed, my Lord.
Yes. Tribunal has passed, and previous year were allowed, subsequent year you were allowed.
Against that.
And this is a statutory liability, my Lord. I have no choice. And apart from everything else, it's tax neutral. I can take it back to here, even if they say don't, next year they have to allow it, my Lord. Once the payment is made.
Since this department has come.
That has check up.
Since this department has come.
Department has not come in a bill.
Lord, I have not checked up. Lord. Right.
That is why I told him I'm giving it to you. Look at it.
Yeah, you see, Mr. Yashovan Das, Senior Counsel, has handed over a copy of an order dated 19th September 2022, passed by the Income Tax Appellate Tribunal, Cuttack Bench, Cuttack.
Subsequently,
The SSC's own case for AYs 2010-11, 11-12, and 12-13, where the same issue has been decided in favor of the.
This is bonus, my lord. Only thing is that is salary. This is bonus. No other difference, my lord. On accrual basis, my lord, I'm supposed to be maintaining under CSS.
Where similar issues.
Yes.
Concerning has been answered in favor of the SSC and against the revenue. Mr. Satpathy states that he would like to examine the order and make submissions on the next date. Interim order to continue. That right in the beginning, you say the counter affidavit of the revenue is taken on record. Rejoinder that if any be filed for the next date. If you want to file a rejoinder, the counter, if you want to file a rejoinder, you file it.
No, my lord, I cannot improve anything.
If any. If you want to, you file.
Yeah.
No compulsion. Interim order to continue. On 21st March. All right.
Interim order to continue.
We have said that, sir.
Deep look.
Item 76.
May it please, Milords. Milords, come this side because Milords, in 76, Milords, I'm being led by my learned senior, Mr. Ishwar. Milords, I pray for a short accommodation if your lordship would feel it convenient, Milords, 22nd if possible, Milords.
Of this month? No.
Can it be then 8th of December, Milords? I'm sorry, Milords.
This is after notice.
Yes. Counter rejoined, everything's filed, Milords. So
what's the hurry then? Is there an interim order?
Yes, Milords.
Then there's no urgency in this. Counsel of the petitioner states that he's in some difficulty today. Interim order to continue. List on. 22nd March. Right.
2nd March.
22nd.
22nd.
Great. Item number 77.
May I please? During pendency of the writ petition, my lord, the department has communicated orders. So I wants to amend the original writ petition. So
No, you file a fresh writ petition, sir.
Next.
Counsel of the petitioner states that in view of the subsequent developments, he wishes to withdraw the present writ petition and file a fresh writ petition in accordance with law. Dispose as withdrawn as liberty is prayed for. All right.
Item number 78.
Lordship, item 78. I may be permitted a counter, your lordship, more 4 weeks time.
All right.
Interim order to continue.
Yeah. 4 more weeks time is granted to the opposite parties to file the reply, rejoined for the next date. Interim order to continue. 23rd March.
Obliged to. Great.
Item number 80. Item number 80.
My lord, in this case, I am appearing for the opposite party, Odisha State Breweries Corporation.
All right. None appears for the petitioner dismissed in opposition.
Item number 81.
Here, the petitioner challenges the demand notice issued by the Odisha State Beverage Corporation with regard to TCS. Now, this Court has in a lot of cases has been passed the demand notice. Also, I have given the order and I have corrected the date of demand. And here, OSBC, Odisha State Beverage Corporation has issued demand notice. They are saying, sir, undue benefit has given to retailers by the license. So that has been, the judgment, main judgment is, Saraswati Sahu case.
Yes, Mr. Monty, same order. All right.
82.
No, same. 82, 83, 84, 85. Same.
All right, all four. Same.
Only demand notice annexure 3 in every case, but shop's name to be changed. I have in para 3, I have stated the shop's name.
Item 86.
All right.
86, yesterday I have received the counter. I'll file rejoinder.
Rejoinder will be filed for the next date, 23rd March.
87, 88, 89, they have not filed counters.
Replies be filed within 4 weeks, rejoinder for the next date.
This is 86. 86, they have filed counter, I will file rejoinder. But other matters, they have not.
87, 88, 89.
87,
87, 88 and 89. 23rd March.
23rd March.
Item number 90.
My lord, 87, 88, 89. What's the date?
23rd March.
27 March.
23rd. Item number 90.
I'll be praying for some more time.
90.
90.
All right. At the request of Mr. 14th March.
8th March.
14.
Not my name may be deleted.
All right. The name of Mr. T.K. Satpathy be deleted.
My learned friend is appearing.
From the
both
the appearance for the from appearance for either party. Yeah.
Both the cases, my appearance is
No, it's already there. My learned friend's name is already there.
Yes.
Item number 79.
43.
79.
43, Lordship. Item number 43. 43 item 43.
Sorry, there's one pass over.
Item number 43. Passed over.
Please.
Item 43.
There is some defect, Lordship. So, Lordship, 1 week time may be given. So
All right. Defects be removed within a week, list thereafter. All right.
Now 79.
For my learned friends begin, my lord, there are some matters of mine, my lords, where there are no reasons, my lord, or 148 AB is in one direction, the final order is another, my lords. To demonstrate one, my lord, there was a notice against a partnership firm, my lords. I file a reply that this partnership firm is already dissolved since 2016, my lords. Still, my lord, they pass an order under 148 AD, my lords. In another, my lords, I showed them reasons, my lord, regarding an agricultural land beyond the municipal limit. All they do, my lord, is they said it needs further verification, and it needs further verification, and they leave it at that, my lords. My humble submissions would be, my lord, a reassessment, my lord, after verification can only be done, my lords. Without a verification, they can't say that it needs further verification. So there are certain matters, my lord, which may not be covered by the general argument which was being raised by my learned senior, Mr. Sahu. So may I just pray your lordship take it up separately, my lords.
We'll take up each matter separately.
Sorry,
we'll take up, obviously, each of you will be heard separately.
So there are certain general arguments.
Yes.
Mine would be something much different from
All right, at the end of all of this, whichever the sequence you want.
Today I am with the revenue.
All right.
Because the bouncers will come and it is very difficult to talk. So I thought that yes, I must come to the revenue side. So therefore, my lords, as otherwise, if I swim against
I think they've all come this side, sir.
I will come that side.
No. They have all come this side. The revenue has come this side.
Oh, yes. I was first sitting there.
I know.
Then I requested.
They're more scared of your bouncers.
No, I am very soft spoken.
No, here also, my lord, subject to my learned friend, Mr. Ray's submissions, my lord. Since these matters are being approved by a higher authority, which I was trying to tell you, your lordships,
right,
yesterday, my lord.
Right.
Your lordships may dispose it of in the direction.
Yes.
All these questions in some of the matters.
I'm coming to that. My lords,
I was just suggesting to my lord.
Yesterday night, we had a discussion over phone. Then I also agreed to his, instead of taking your lordships to all these Hayden's rule and all these things, I decided that the question of jurisdiction should be raised as a preliminary issue before the assessing officer, and for that, I am giving a judgment of this honorable court. My lords, here, Lordship on the previous date has read the provision, the proviso to section 148.
Right.
No notice shall be issued. I don't know, back there.
New.
8 years. Barcode nothing. Barcode 140. Ease of the information. Lordship may kindly again peruse. I'll be much obliged if your Lordship may kindly peruse. Provided that no notice under this section shall be issued unless there is a information with the AO which suggests that the income chargeable to tax has escaped assessment in the case of the assessee for the relevant assessment year, and the assessing officer has obtained prior approval of the specified authority to issue such notice. I have argued, my lords, all this is dependent on section 149. That is the mischief which has been removed by section, introducing section 149, the limitation. So I beseech upon your lordships that Lordship may permit in some cases, I'll go and appear before the AO. And I further beseech that this ground of limitation
also be raised,
may be treated as a preliminary issue before he adjudicates. I think the revenue shall not be prejudiced in that sense. Ultimately, I have to appear before him. I cannot hide. There is no
no escape.
Yes.
Income may escape, but you will not.
My lords, I'll just play a few lines. That is para 5 of the judgment which I have given.
Right.
Lordship may be pleased to see para 5.
Yes.
Here, a 12-8 under the old OST Act was initiated.
Right.
That was challenged for this honorable court.
Right.
This honorable court relegated the assessee, was the assessment order, relegated the assessee to again appear before the AO and raise that he has no jurisdiction. And the honorable court directed that if such a issue is raised, it may be treated as a preliminary issue by taking into consideration Order 14, Rule 2 of the CPC.
Right.
May I place that petitioner has valuable right of questioning of the taxing authority, showing absence of those conditions which provide jurisdiction and validity of proceedings for reassessment. It has not been disputed, and in our view, rightly, that the petitioner has right of questioning jurisdiction of the taxing authority and to show absence of basic facts and untenability of the proposed action and duty of the authority to answer the same when put in issue. Full stop. The case of reopening should be conclusive and not conjectured. Should be sure. Yes. May I continue, my lords?
Please.
Sure and not speculative, positive and not perverse. Full stop. In case the assessing officer is satisfied that the proceeding would turn out to be in exercise is in futility. There's a typographical mistake.
Correct.
In futility and would involve chance of escaped assessment and not escaped assessment. mere chance of escaped assessment and not escaped assessment, he may discontinue it. Full stop. We therefore direct that in case
The petitioner.
Petitioner indicated.
Petitioner indicated it stand before the sales tax officer regarding absence of reason or lack of jurisdiction, as well as alleged absence of materials necessitating reopening of the sales tax officer shall consider those aspects.
I use a very standard phrase. I say you are permitted to raise all the points you have raised in the present petition.
Yes.
As well as any other points you may have in accordance with.
That is correct. I bow down before Lordship. But I know, I have guessed that your Lordship will remit. But my respectful submission, and therefore I beseech upon your Lordship. Therefore, I have tried to persuade my lords that the introduction of section 149, by virtue of which only if satisfied, he assumes the assessing officer is clothed with the power to reopen the assessment, as otherwise he cannot assume the jurisdiction to proceed with the matters, with the reopening proceeding. My lords, since it has been approved by the apex court, my lords, Lordship knows one Supreme Court judge of the American Supreme Court, he said that we are supreme because no appeal lies from us.
Supreme, but not infallible.
And therefore, my lords, I know that this is a greatest hurdle in my case. And if I swim against the current, my ribs will be injured.
He is already injured.
I am already injured, my lord. 8 to 10 days back, I had a fall in the bathroom. By this, I fell like that.
I see.
And as a result of which, my lord, still I had the pain, but I came out.
I suggested you please do not think about income tax much, my lords.
No, I am not thinking of much about the income tax, but of the bouncers of the revenue.
But I noticed you managed to get Mr. Sunil Mishra to your side.
He has a very excellent case along with us, my lords. So I told him, Lord, you can't be on the other side. You have to be with us.
Right. At least for the timing.
For the revenue.
So, my lord, timing, Lord, he'll be supporting us.
Yes.
And so that will dispose of much of the cases in my list, except one. That is with Mr. Chimanka. And that is KIT. This number WPC file brief 80.
17972.
Yes.
Yes. My lords, I'll show just two things.
Give us the number.
Sir, number is 17922 of 2022.
972.
Are brief. Brief ta kai mo?
Yes.
Brief. Now, my lords, may kindly see, notice under section 148A(b) was issued by the annexer 1
on 24th May.
Yes. Then our lordship will be pleased to see annexer 3. Sorry, my lords. I'm sorry. Objection annexer 5 issued and electronically, and also that I have given by way of an affidavit and submitted in the court. I would a copy. Neon the upper side could need Lordship may kindly permit me only. I request your lordship to have 2 minutes. Give me.
Yes, yes.
It will not be more than that.
Yes, yes.
Lordship may kindly see. That objection, it has been given. Amar kahin copy ta? Affidavit ka copy? I have given it by way of an affidavit, and the on assessment area is 1517 and the board copy. It has been annexer A to my affidavit at page 3. Lordship will kindly see the same was communicated. Thakur date na seta acknowledgement number. Date ta kebe dele mo?
Deriving income. Who
did receive college? They have received it on the 3rd of June 2022.
And
that is the acknowledgement I have given and copy has been served.
Right.
And till date, no order under section 148A, capital A, small d has been issued. And the proceeding, therefore, is completely vitiated.
No, they've not filed a reply in this.
They have not filed a reply. I will say, my lords,
What is this annexure A?
Annexure A is the acknowledgement of
order.
Annexure A.
Affidavit flag B.
Yes.
You have enclosed the order at one.
No. That was That was
148A-D order, sir.
No, my lords.
Yes.
It is 148A-D. Thereafter, my lords, I came before your lordships.
That I have to check, my lord.
Yes.
No. 25th July is a 148A-D order.
24th of
25th July.
Yes. Just a minute. 452022. Notice was issued on 4/5. That was the 4/5. Notice was issued on under section 148A-B on 24th of May.
Correct, sir. And your reply was on 3rd June.
3rd June. Yes.
Pursuant thereto, they've passed this 148A-D order.
Pursuant to that, my lords.
On 25th July.
I'm sorry, my lords. If kindly see annexure 6.
No, but come to your affidavit flag B.
Flag B.
Your own affidavit, sir.
Yes.
Affidavit dated 28 June.
Yes.
And that annexure to that affidavit.
Annexure A.
Annexure A.
That's how you have filed this amendment application, sir. You want to challenge that order also. That's how you filed this application.
Yes.
Amendment, then consolidated, not filed. Consolidated petition also.
No. He is only now moving this application, sir. It's not been allowed yet.
24th of May 2022. Then the...
Say 25th July is that 148A-D order.
My lords.
So you want to challenge that order and therefore you have handed over an IA to us.
IA for amendment.
To challenge that order.
Amendment with prayer. You are sought to amend your prayer also.
To quash that order.
my lords.
Annexure 1 as well as Annexure 8.
"24th of May, notice was issued, and I have submitted the reply. Thereafter, D, Lord. Lordship may give me some time.
The point will raise before the assessment. No, everything they raised here, they can.
Notice was issued that my lords,
No, here, correct.
and thereafter, on 24th of May, they issued this. I again approached before your dishonorable court, my lords, and I filed that objection. My lords, on 3/6. Now, from 1 month from the date of that 148 D order,
25th July.
Huh?
25th July.
25th of July. Yes. So, I think 1 month from the date of the receipt, it ends on 30th of June.
It's within times.
Yes.
From 30th June.
Then
From 30th
nothing
June,
to
1 month.
beg your pardon?
From 30th June, 1 month.
Yes. Then I cannot
So this will also go the same way, sir.
Yes. And here, my lords, lordship may also, another issue rises here. Apart from the limitation regarding change of opinion.
Every point, sir. We will say all points raised by you and any further points that you may wish to raise in accordance with law.
I humbly bow down before lordships.
That's right.
Because, my lords, why I am saying
no point is left unnoticed.
So I'd only add to my learned friend's suggestion, my lords.
Yes.
So I'd only humbly say that all the issues raised regarding non-consideration of objections, inquiry, opportunity of personal hearing, then questions of limitation and determination of estimate of income with documentary evidence.
All right.
And while doing so, my lord, he will not be influenced by the orders, my lord,
correct.
passed under 148 AD.
Correct.
Yes.
Because why I say so, my lord, your lordships knows that at each stage.
No. In fact, yesterday I think I was mentioning it can't be the same nature of consideration. So the nature of consideration at 148 has to be different.
My lords. And I'd only humbly pray your lordship to keep this in mind and allow us, my lord, to place some individual cases where there is total non-application of mind, and your lordship would prima facie be satisfied, my lord, there was no inquiry at all, my lords. Even though it has been said that there was an inquiry.
And ultimately we'll reach the same point.
Your lordship would accept, your lordship would accept to us our contention, at least my contention, that a 148 AD proceeding. The 148 AD proceeding, my lord, cannot be initiated against a non-existent firm, my lords. At least at that part, my lord, your lordship would agree with me, my lords.
Have they filed a reply in your
representative assist?
They have not filed a reply.
You can keep that separately for consideration.
In one case,
whichever matters you say that you'll go before the AO, we'll record those matters. The others, let them file replies.
Only praise out the particulars which will be binding on him to examine.
I'll dictate the order. You can make a note of it. So you say counsel to the petitioners. I'll just pass this order. Then you tell me in which orders this will
Yes.
Counsel, the petitioners seek leave to withdraw all these petitions.
Now, Lordship may will be misunderstood. This petition are disposed of. Withdrawal is something, my lords.
All right, then we'll have to quote that Punjab and Haryana. Then Supreme Court order.
Yes.
May I, before your lord, ask your lordship may just give me a minute.
No. In fact, I'll first ask them which matters they want this order to apply in. All the remaining matters where you say, no, we don't want this order, we want to argue, we'll hear you.
All I'm saying, Milords, before that aspect, we just wish to bring certain facts, the position of law, Milords, to your lordship.
So we'll hear you on that.
Very well.
Whatever petitions you want to argue, you argue. We are not foreclosing that at all. There are some of them who wish to go before the assessing officer. We are permitting them to do that. All right. In these petitions, the challenge is raised both to the notice issued to the petitioner under section 148 capital A bracket small b of the Income Tax Act 1961, followed by the order passed under section 148 capital A bracket D of the Act on various grounds, including the failure to conduct an inquiry, the failure to consider the objections, the failure to be afforded a hearing, and the failure to consider various other points that have been raised in the present petition. Stop. Paragraph. The Punjab and Haryana High Court had, in a judgment dated 2nd June 2022, where is the Supreme Court order? In CWP 9142 of 2022, bracket, Gyan Castings Private Limited versus CBDT and others, bracket, declined to interfere in a writ petition raising a similar challenge to similar notices and orders issued under sections 148 capital A bracket B and section 148 capital A bracket small d of the Act, and permitted the petitioners there to participate. No, declined to interfere. Open quotation, at this intermediate stage when proceedings initiated are yet to be concluded by a statutory authority. Unquote. It is clarified that nothing observed in that order would be considered as an opinion on the merits of the case. Paragraph. The above judgment was challenged before the Supreme Court of India in SLP Civil 10762 of 2022. In which, on 17 June 2022, while dismissing the SLP, the following order was passed by the Supreme Court. Just reproduce the whole order. Paragraph. In the present cases too, this court is inclined to follow the aforementioned order of the Supreme Court and permit the petitioners to raise all the issues
to participate in the proceedings matters
urged in the present petition.
Yes.
Before the assessing officer.
Reassessment proceedings.
In the reassessment proceedings under section 148 of the Act. Apart from any other issue that they may have in accordance with law. Full stop. While considering all such submissions and passing an order under section 148 of the Act, the assessing officer.
148, it will be then 147, read with 143.
Yeah, under 147, read with 148 of the Act.
143.3, because 143 bracketed 3 is the procedure for completing the assessment.
All right. Under section 147, read with section 143 bracket 3. The AO will not be influenced by the fact that by the order passed under section 148 capital A bracket D of the Act.
Yes.
Stop.
So I'll be failing in my duties, my lord, to bring on record a judgment of the Calcutta High Court after the Supreme Court's order, my lord. Your lordship, may just keep note of it. My lord, they considered Anshul Jain of the Supreme Court at page 5, my lords. And they say if this procedural irregularity leading to violation of principles of natural justice, 226 is always open, my lords.
Yes,
And
yes, there's always there.
My lord. And this Anshul Jain was followed, my lords.
Correct.
At page 5, my lords.
Correct.
So,
My lords.
refer that was an objection raised by the revenue that was considered, and the lordships of the Honorable Supreme Court and your lordship to appreciate that this is an order in appeal, my lords. A single judge was reluctant to pass any orders. Then the matter went up in appeal, and in appeal, my lord, they interfered and said that since there's a violation of principles of natural justice and procedural irregularities, and the finding your lordship would appreciate. Nine. Lordship, may kindly see page 3, my lords. Page 3, last paragraph, on a reading of the said order. Here, my lord, the order under 148A was challenged.
I know, and then quashed and sent back to the assessing office.
So because we also rely on this.
This honorable
In that case, we'll pass a full-fledged judgment then.
My one case
Judgment panel.
Full-fledged judgment.
We are scared.
Covered by this honorable judgment. Your lordship, what happened here in this case?
No. So I'm just saying this is what we've dictated. We've not even indicated the petition numbers. What I can do is we can hear all of you, hear the revenue, and then pass whatever orders. We'll discuss all the judgments and discuss all the points. I think that's better. Instead of this piecemeal thing, because each one wants to argue.
Yes.
See, even Mr. Kara wants to cite this judgment and that. So it's better, and they may want to cite many more judgments.
No, I was only trying to point out about the procedural irregularities.
I know. So I'm saying we'll have to deal with all of that.
Yes.
Let's hear all of you properly.
Yes.
Hear you also then. Yeah. Correct. But that's how they want. Each one wants to argue their own case. So
no, we were trying to only differentiate because whatever your lordships have dictated may cover many of the matters.
Right.
But there are some matters, my lord, where your lordship prima facie would be satisfied that this will not be a petition.
Actually, short of, I was just thinking of it, if none of you is withdrawing your cases, then we'll have to give full reasons why we are adopting this course, what we are adopting.
Correct. Correct.
So it's better to argue, all of you argue your cases.
Yes.
Then
Yes. That will be.
We run a risk there.
Yes. Yeah.
Siddhartha,
sir.
Seated how Calcutta judge should be charged with food question to better.
there's already an order of this division bench.
Yes, yes.
Justice Raman's judgment.
Yes, yes, my lord. In my case, order has been passed.
Two judgments are along with Honorable Justice Jaswant.
But what I find, my lords have authored very good judgment, my lords. The judgment rendered by my lord, Honorable Justice Raman in Stuart Science College case. Stuart Science College case. That is a case, 148A is notice was issued, reply was filed, reply considered, and challenging the 148A 1D order petition has come before your lordship. And my lord said that no, all these things can be agitated before the.
In that case, return was filed under section, after the order was passed, under section 148 bracketed D, the petitioner chose to file the return.
Yes.
And claimed exemption. And therefore, since there was a participation, this honorable court rightly declined to interfere. That since participation is there, and I found from the judgment, my lords, there is
so unless you persuade this bench that this bench judgment is wrong,
yes,
the coordinate bench.
Yes, my lord, is in order to I am distinguishing it.
That is a different.
Here, none of the petitioners before your lordship has participated in the proceeding. My lords, where it triggers, it triggers the reassessment proceeding is triggered when a notice, in compliance to the notice issued under section 148D, order is passed, notice is attached that you file your return within such and such date. That hearing of the reassessment proceeding. Now, my lords, this stage has not yet reached, and before that, we approached this honorable court, and this honorable court, by an interim order, gave stay of further proceeding. I remember the date, my lords. Now, the date, the first case on this issue was before your lordship, my lord Chief Justice and my lord Justice R.K. Patnaik. And I found a very, very tough fight. And Mr. Chibmakar, your lordship said the same thing, that Mr. Rai will get the same chance when the reassessment proceeding is there.
Correct.
Then I pressed into that ordi alteram theory. My lords, after great persuasion, your lordship issued notice and gave an interim stay. And thereafter, my lords, matters were filed. Your lordship said on the very day I remember that this will open
another full chain,
yes,
which it did.
But your lordship was kind enough to notice in that case. That was the first case. That is Pasupati Ispat, my lords. That is also today in the list.
Correct.
My lords, now I distinguish it.
Yes.
So far as lordship will, factually,
yes,
he claimed, the Stuart Science College claimed that I am exempted under section 1023 CCC.
Correct.
Okay, my lords. Therefore, they said that the assessing officer has no jurisdiction,
right,
to ask me to file return.
Correct.
While saying this, he filed a return,
right,
and participated in the proceeding.
Right.
And it was found by this honorable court that yes, you have participated.
Correct.
So that completely distinguishes the cases at hand.
All right.
My lords, then just bring to your lordships.
No, so let's do an organized thing. We'll finish hearing Mr. Sahu.
Yes, yes.
And
yes,
then we'll each hear each of you.
Yes.
All right. All right. So that whole thing will take off. Yes.
My lords.
Finished, or you still have some?
I have, but I will not take much time.
All right.
Barring only, I will be pointing out 2-3 provisions and 1-2 judgments.
Okay.
Because your lordship on the yesterday was on the issue of timeline.
Correct.
I was also pointing out to your lordship lords.
Correct.
WPC 9191 of 2022.
Yes, sir.
Plus, my case was
Which are your writ petitions, Mr. Sahu?
9191 of 2022 matters. The first matter.
Right.
Minus.
Only one matter.
Minus. Because yesterday I had pointed out, because in that case only because 4 dates are involved. Very small thing. Because one notice dated 7/3/2022. Time petition had annexure 2 dated 15/3/2022. Because report is on the record. Because available record. 3 is the reply dated 23/3/2022. Because show cause reply. And order dated 26/3/2022, which I have yesterday placed before lordship that this is within no period. Notice period, your lordship have said 148 AB, minimum 7 days, maximum 30 days. And ordering period belongs 30 days from the date of the reply.
So I thought you distinguished the Punjab and Haryana judgment by saying there they considered objections. In your case, they've not considered the objections.
Exactly.
And therefore, that judgment does not apply.
Correct, absolutely correct. And 2 judgments also, before I start, my lords. One, this Stuart Science College I have given to lordship. And other judgment also, my Lord Honorable Justice Raman has also authored, along with my Lord Honorable Justice Jaswant Singh. It's also a very lengthy judgment. I will give a copy to your lordship, my lords. That is also, my lords, deals with different facts, my lords. In that case, what has happened? No reply was filed. No stay. My lords may kindly see a copy of the judgment I am giving to lordship, my lords. Paragraph 3.1 of my lord's judgment. I'm sorry, one copy I have given. Paragraph 3.1. Yes.
This or a global contract.
Yes, paragraph 3.1. There was no response from the SSC, nor was any step taken for extension of time or before 22/3/2022 as stipulated the aforesaid notice dated 15/3/2022 by order dated 26/3/2022 passed under section 128D of the income tax. Detailed discussion is made. So that's what this is totally. 3.4, your lordship will find also that is participation. On 26/9/18 under 139(1) was processed and intimation of refund was issued on 14/4/19. However, response notice dated 26/3/2022, that is 148 notice. The petition assessor filed his revised return in form ITR 6 for the assessment year 2018-19.
So therefore, in Oro Global's case, Milots, as per order dated 26/3/2022, passed under section 148A small d, a notice was also issued under section 148. Pursuant to that notice under section 148, as my lords know, notice also goes under 142(1) invite filing of return. That return was also filed by the assessee, lords. He participated in 148 proceeding, and the return so filed was also successfully verified on 28/3/2025/2022. So that is the case. So therefore, at that stage, the petitioner has approached your lordship, and your lordship said, now that in view of all this, you participate, agitate whatever events you have, so that the assessing authority will consider and take care of your defense. But so far as this case is concerned, I stand completely different footing there. And there is no denying the fact, as per the report by direction, and the adjournment application is on record below. If your lordship will call for records also, kind enough, your lordship will be at call for. My lord can also verify at my lord's end. If there is a time petition, it is the duty of the assessing officer, keeping in mind the very scheme under 148A, to deal with it, either to reject the application or to allow time. And the notice period is 7 days to 30 days. And much before completion of 30 days, instead of dealing with my adjournment, a prayer for adjournment, my lord, he disposed of under 148A, my lord. But that is only to that extent. Otherwise, I won't have, probably I could have agreed with the order which you are also proposing. I would have given my lord. But at a stage where the petitioner submits application for grant of adjournment, praying for 7 days time, that has not been dealt in. My friend...
you relied on a Delhi High Court, Divya or something, right? You relied on Delhi High Court judgment.
Minus. And there, Honorable Delhi High Court says, even it can be, there can be auto grant also, even to that extent.
Divya or something.
Minus. Anyway, now, Divya Capital, yes. There's two provisions which I was pointing out. That is on timeline. Why the assessing officer should not be in a hurry? Because of the provision under 149. Section 149, time limit for notice. Yes. Your lordship will find there is a proviso, that is third proviso. If your lordship permit me, I will place the whole provision, or I will directly take my lordship and third provision.
This is still high.
No notice. Sorry, section 149.
Yes. Yes, no notice under section 148.
No notice under section 148 shall be issued for the relevant assessment year if 3 years are the end of the relevant assessment year, unless the case falls under clause B. Clause B deals with 10 years. More than 3 years and less than more than 10 years. If 3 years but more than 10 years have elapsed from the end of the relevant assessment, unless I don't know belong to this B category. That is in the context of where assets acquired is inviting escaped assessment more than 50 lakhs. Then, sir, your lordship kindly see third proviso. Provided also that for the purposes of computing the period of limitation as per the time or extended time allowed to the assessee as per so-called notice issued under clause B of section 148A, or the period during which the proceeding under section 148A is stayed by an order or injunction by any court shall be excluded. These are all exclusions. So therefore, why this is there, the whole legislative intent is to avoid unnecessary litigation, to reduce it only to the extent it is required under law to initiate belongs. So therefore, this pre-decisional hearing, this belongs anterior stage of initiating proceeding belongs to curve unnecessarily expanding the proceeding belongs as was happening earlier, consequent to tribe shaft belongs case, GK and tribe shaft case belongs. So those are the materials your lordship have to have mind belongs to find out whether justiciable actions are taken by assessing officer or it can invite belongs action from the lordship's end belongs. Then now coming to belongs hearing, your lordship will find two provisions I will bring to lordship's notice belongs. I will remind your Lordship, there is a circular by CBC, my lords have come across, we have pointed out pre-consultation process in the service tax law before initiating 70 proceeding. Because that is intended to do away with unnecessary proceeding. Even if someone agrees to pay during prior to issue of notice, it can proceed with abate there and there. There is no need for the issue notice also.
Correct.
So in the line of that, this is comprehended.
Right.
Now, 151A,
yes.
Why I say so, that also refers to 148A.
Right.
Faceless assessment of escaping assessment.
Right.
I will tell you, my lords, why hearing is required. Even legislature also provides not by you guys will also have framed the question in my case also that to explain whether for the purpose of 148A this reply to notice will suffice or physical hearing is at all required.
Right.
Your Lordship, may kindly see 151 capital A.
Yes.
The central government may make a scheme. My lords,
yes, yes.
Well, may make a scheme by notification in the computation under section 147 or issue of notice under 148 or conducting inquiry or issuance of show cause notice or passing of order under section 148A or sanction for issue of such notice under 151 so as to import greater efficiency, transparency and accountability by eliminating interface for income tax authority so and so, optimizing utilization so and so, introducing time-based assessment, reassessment so and so. Then subpara 2. That is very important. The central government may, for the purpose of giving effect to scheme made under subsection 1 by notification in the official gazette, direct that any of the provisions of this act shall not apply or shall apply with such exceptions, modifications, adaptations as may be specified notification, provided that no direction shall issue after 31/3/2022. Now, your Lordship may kindly see the notified scheme. I have appended in my compilation.
All right.
That is first document, the compilation.
Right.
That's my lord's got it. List of documents along with the memo I have filed on 4/5/2022.
Scheme.
First document, Ministry of Finance, Central Board Direct Act, New Delhi, dated 29/3/2022. That is prior to 31/3, because that is the date beyond which government cannot make such a scheme. Now, in exchange of power conferred to subsection 1 and 2 of section 151A of the Income Tax Act, the central government hereby makes the following scheme, namely, subtitle. This scheme may be called the E-Assessment of Income Escaping Assessment Scheme 2022. It shall come into force from the date of publication in the official gazette. Definition in the scheme unless the context otherwise requires. Your Lordship may kindly omit, there are some interruptions that has come in while printing. Act means Income Tax Act. Automation, automated allocation means an algorithm of randomized allocation of cases by using suitable technological tools, including artificial intelligence and machine learning, with a view to optimize the use of resources. Words and expressions herein used are not defined, but defined in the Act shall have the meaning respectively assigned to them in the Act. Scope of the scheme. Now, for the purpose of scheme, reassessment or recomputation under section 147, issuance of notice under section 148 of the Act shall be through automated allocation in accordance with risk management strategy formulated by the board as referred to in section 148 Act for issuance of notice and in a faceless manner to the extent provided under 144B of the Act with reference to making assessment reassessment of total assets. So therefore, it specifically excludes 148A mirrors.
Right.
My humble submission before Lordship is 148 is inside the purview of faceless assessment. 48A. So therefore, here 148A as it stands mirrors provides for opportunity of hearing, which under the scheme formulated by the central government pursuant to exercise of power under 151, having not included that and allowing opportunity of hearing, mirrors by no imagination it can be comprehended to have been, when it is specifically excluded, that cannot be comprehended to have been included. It is an exclusion and opportunity of hearing provided under 148A mirrors. That is my humble submission so far as apparent reading of the provision itself is concerned. Now, only 2 judgments I will bring to Lordship's notice. So one is Patna High Court judgment, my lords, in the case of Commissioner of Wealth Tax versus Jagdish Prasad Chaudhary, my lords. But the question involved in this case, my lords, may kindly see paragraph 2, my lords.
Does it have a citation? AAR 1996.
Yes, citation AAR 1996, Patna 58, my lord.
Right.
My lords. Whether on the facts and circumstantial case, the tribunal justified in cancelling the penalties imposed under section 18(1) of the Wealth Tax Act on the ground that no reasonable opportunity of being heard was given by the successor wealth tax officer before passing the order imposing penalties under 18(1) of the aforesaid act to the assessee by the assessment year 68, 69, 70, 71. That's while interpreting the contours of the expression, without opportunity to be heard, that's what can be the interpretation lawfully it can be. My lords, may kindly see paragraph 37, my lords.
Yes.
Paragraph 37, your lordship will find, I'm sorry, paragraph 38 will do, my lords. Paragraph 38, sorry.
Right.
Though there are some vital contextual differences between grant of opportunity of being heard to a member of the civil services and to an association of the act, substantially and on principle the same, namely, a grant of reasonable opportunity to be heard against the imposition of penalty. In such a context, the Supreme Court has, by the words hearing, obviously meant an oral hearing. I respectfully adopt the said elucidation of the scope of hearing in respect to legislative intent behind the expression reasonably opportunity of being heard, occurring in section 18(2) of the said act. And this expression is quite resembling with the expression available.
Actually, what happens is if there is a finality to a certain order,
my lords,
and beyond which there's no remedy at all,
my lords,
then in those kind of contexts, hearing would mean oral hearing. This is what I've understood. But that's why the context becomes very important. So one argument in response to this could be, this don't say that now this is our argument or anything.
My lords.
This is a way of dealing with arguments.
My lords.
One possible response to your argument could be that in this context, where it's only like a screening or a preliminary exercise before issuing 148,
correct,
this does not require that kind of an oral hearing, and because there's no finality in that sense.
My lord.
Even if the man comes to an opinion under 148A(d), that will not be binding when he actually sits to consider under 148 the reassessment.
There's a difficulty.
Because this is kind of like a GK and drive shafts exercise.
Yes.
In GK and drive shafts, when they reject your objection,
right,
it does not mean in all those cases, 147, it will be reopened and reassessment will happen and demand will be increased. It's not true. There have been instances where rejecting your objections under GK and drive shafts, in 147, they have reaffirmed the original assessment.
Right.
But the very nature of this exercise is not to attach a finality which can never be disturbed.
Right.
The same officer who's disposing of your objections under 148A(d) will be sitting for the reassessment, the designation wise. I mean, same officer doesn't mean the same individual. The same designation. Officer of the same designation will be dealing with your reassessment exercise.
So now therefore,
he will not say, oh, I have already under 148A(d) passed this order. I have to do nothing here. I simply have to copy that order and say that it is increased and all that. That is not what the exercise is intended to be.
But I think your lordship have to keep in mind whether 148A is mandatory or directory. That is also
no. Those individual, see, there are individual elements of 148A(d) which could become, a point for argument. Like the argument he was making that you have to dispose of these objections. I mean, pass the order under 148A(d) within 1 month from the end of the month where the reply is filed. So Mr. Rai is pointing out 4 or 5 cases where it is passed 2 months later and all that. So we'll have to hear their arguments on how they deal with that.
Correct.
Whether even in those cases, one has to still go before the assessing officer and point out, no, this is delayed.
Correct.
What is the point? If you know it is delayed, it's delayed. Do you still have to go? That's something that they have to answer. Likewise, that 50 lakh rule.
Yes. 50 lakhs.
Suppose it's only some 5 lakhs.
Correct.
How much ever you stretch it, it can't go more than 10 lakhs. You still wait to go before the AO to show, no, under 149, this is, less than 50 lakhs, so you can't proceed in the matter. So these are things they have to answer.
Yes. My humble submission would be, here's the order which is to be passed under 148 AD may not be providing proper reasons. That the reasons may be adequate, may be inadequate. The reason may be sound or unsound. Reason may be consistent or inconsistent. But those are not to be scrutinized by Lordship. But what your Lordship is required to scrutinize
the procedural aspects.
Exactly. That is what my humble is.
Correct. That's what everybody is arguing.
And
nobody is arguing on anything other than procedure.
Correct. And 226 never denude your Lordship's power. Look into that.
Correct.
To that extent, only my humble submission. Yes. So, and one more paragraph, para 40 only. I'll conclude. I hold that.
There could be a rule of bias. We never know. I'm saying there could be a civil dispute going on between the officer who passed the order and the person against whom he's passed the order.
Correct.
He should have recused himself, saying, no, I have a civil dispute with him, or I filed a criminal complaint against him. Right. A criminal complaint is facing. There we won't say, no, 226 means you still have to go to that and not why he should recuse. We will not, obviously. Right. So there will be many such instances, egregious circumstances where 226 will be exercised.
Right.
It's not a blanket ban saying never 226.
Absolutely.
So there is a jurisdiction in the High Court. It might choose not to exercise that jurisdiction.
Correct.
So I'd only add, there may be an element of institutional bias. Because in the entire scheme of 148...
that is, I think that you made yesterday also.
Yes,
But the very nature of this is that, you're not supposed to, if you say institutional bias, there can never be a 148A exercise at all. That 148A exercise has to be only by some superior officer, or the 148 exercise has to be by a superior officer.
Once my humble submission would be that once a superior officer gives an approval to this order passed in 148A-D, my lords, how far, my lord, the 148...
So then 148 will only have to be done by the income tax tribunal?
No, not at all.
No, we have to be logical to this.
No, so what...
When you say institutional bias, then you can say that all income tax officers are all bound by each other's opinions. Then institution that the whole income tax department can't deal with it. Once one officer of the income tax department deals with at one stage, no officer can deal with it.
So what I was trying to say, my lord, is there's some element of, my lord's, sanctity attached to those orders.
I'm not sure at all.
So that would be my humble
every authority is a quasi-judicial authority who's supposed to exercise his functions in accordance with the law.
I think that is because of the doctrine of necessity.
Not
only necessity, but it's that the nature of the function is different.
Yes.
Let's take administrative decision of the High Court. Like we sit as a full court and we say some officer has to be compulsorily retired. If this rule of institutional bias comes, no writ petition can be entertained by the High Court. Which is not only a writ petition is entertained, but the decision of a full court is reversed by two judges of the High Court. So where's the institutional bias then?
Because your lordships are deciding it in an administrative capacity, here in a judicial capacity.
Exactly. Although the very two judges could have been part of that full court dealing with that.
In our High Court, it is.
Every High Court.
In our High Court, it has happened.
It has happened in every High Court, sir. It has happened in every High Court.
That's why I was just humbly making a submission that without being influenced by any observation of this 148 AD order, which your lordships were dictating, they can deal with this matter.
That is obvious. We're only making what is obvious even more clear by adding that line that he will not be influenced by what he did in 148 AD. So that's very obvious. In fact, that would give you a ground to challenge in case he does a cut paste. He says, in 148 day, I have said this, I'm reproducing that whole order and now confirming setting aside.
Without interfering my learned friend's argument or anyone's argument, my lord. Personally, my lord, I'd feel, my lord, your lordship's first order, my lord, would cover majority part of the cases, except, my lord, for cases where there are apparent mistakes in this 148 AD order, where your lordships may say that he'll reconsider.
Our only difficulty is if it is not a withdrawal of the writ petition for that kind of an order, The first ground of challenge in the SLP is the High Court failed to consider so many arguments of mine. That will be the first ground. I argued for 2 days. I cited 10 judgments and only 2 paragraphs without reflecting any of my arguments has simply been passed. So it's better to say counsel seeks leave to withdraw and, that kind of. If no counsel is willing to withdraw, then we'll have to deal with all arguments. The first ground, I know as counsel, we've been counsel ourselves. First ground will be High Court never considered all these arguments.
Anyway, so major my friends are not arguing. I'll keep that too.
So, can I?
Ask it, please.
May I submit? My lords, it is very risky now. He looks at the watch already. It is very risky for all the petitioners. And Lordship, I have heard Mr. Senior Counsel Sou's argument and also the given by this honorable court. The emphasis on the natural justice, that hearing, your Lordship opined that it has got 148A D order is not
the end of the end of
the day. Well, let's hear. Lordship may take an example. That in my case, I'm just giving 2 lines before I part with this, because the time is very vital. That is, my lords, where the assessee, Pasupati Ispatra anle? Pasupati Ispatra diyon. You have a reply. Mr. Chimanka is there, my lords.
Right.
My lords, 148A, giving reply to 148A-B. I have specifically asked that if any adverse view is taken, then you hear me.
Right.
Now, my lords, whether in this case an opportunity of hearing was necessary, Lordship may kindly see Manaka Gandhi's case. Justice is not only be done, but must have been seen to be done.
Correct.
And another case, my lords, 87 Supreme Court, Institute of Chartered Accountant.
No, but 1 minute. If he's not finished, he'll again say the end of your argument that I have not finished.
Yes, my lord. Sorry. I will finish within.
You were on Moser Bayer. You have to sit side Moser Bayer.
Only 2-3 minutes. Sorry. Now there will be confusion. I have taken the paper of Mr. Kora, and Mr. Kora is, of course, he is not accused. He will telephone me in the night that my paper has been misplaced with you. So I actually let Mr. Sahu complete his
only 2-3 minutes.
मोटा कौन वाला? ठीक है, साहू नहीं है. Sorry. That will be confusion. Therefore, on that day I said I am far from out.
But he's the leader of the madding crowd.
Yes.
That's a Moser beer. Whereas para 4, you also kindly see for a moment.
Right.
The challenge, what is the challenge involved? The challenge to the orders of the transfer pricing officer
which is mounted by the petitioners is common, and it goes as follows. That the transfer pricing officer has not granted an oral hearing determining the arm's length price in respect of international transactions entered into by the petitioners with their associated enterprises. And there has been a failure on the part of the transfer pricing officer to consider the documents and information filed by the petitioners as also non-disclosure information and documents obtained by the transfer pricing officer, which are used by him in the determination of the arm's length price. This is the issue. What is oral hearing then, Lords? My Lords, may kindly see paragraph 43. Paragraph 43.
Yes.
Only I will be taking your Lordship's attention to page 19, internal page 19.
Yes.
It is quite plain upon reading of the provisions of subsection 3 of section 92 CA that the legislature has clearly cast an obligation on the transfer pricing officer to accord an oral hearing to SSC. The submission of the Additional Solicitor General to the contrary is not acceptable to us. It has been reiterated time and again by courts in India and other jurisdictions all over the world that authorities which have a power to decide and whose decisions would prejudice a party entailing civil consequences.
See, all these are the caveats.
Yes, to be required to accord oral, even where the statute is silent.
Correct.
Then our High Court arises out of our High Court decision. State of Odisha versus Dr. Miss Birapani Dei, the court have also gone to the extent of holding that the right to oral hearing may not necessarily flow from a statute, but flows from rule of law as enunciated by courts. That brings us to issue as to what could be regarded as civil consequences in given case. The expression civil consequences has been best explained by our Supreme Court in the case of Mahinder Singh Jail versus Chief Election Commissioner, reported so also. The Supreme Court observed that civil consequences involve not only property and personal rights, but also actions which impinge on civil liberty of an individual or result in material deprivation or even result in non-pecuniary damages. That is what. So this includes the effect that will fall upon us. Now, last paragraph I will proceed.
Mr. Sahu. Actually, what will happen in your case is only that it takes you to a regular kind of a proceeding under 148. Not only no demand will be raised, you will not be asked to pay anything. Actually, nothing is going to be. It's like a rehearsal. You're given an advance notice of what are going to be the grounds on which your assessment is going to be reopened. Like I said yesterday, you're given 2 chances to convince the revenue. This is the first chance to convince the revenue. If you succeed in 148A stage itself, proceedings gets dropped. If he's not able to be satisfied at that stage, you can still satisfy him at 148.
But
it's like a second, it's like an additional opportunity for you.
That is correct.
So that's very different from the context in which we are talking here in para 43.
But I believe, Lords, reasonably, your Lordship will fairly appreciate that the effect of 148A cannot be fortuitous, because meaningful.
No, certainly not. Which is why, if you're able to convince and the whole proceedings get dropped, it's such a saving of time, energy, everyone, not only for the SSC, but for the revenue as well. Then there's no need to pursue the reassessment at all. You drop the reassessment. The revenue agrees with you that, this is not a case for reopening, and it is dropped. So it's not otious.
But if, even we have come across practically in our earlier practice in those days, if we lose the first stage, as your Lordship says, if he has every power to reconsider what he could have considered in 148A, in all fairness, I can say,
that's the very scheme of the Act. You see, there are not only this 148 situation, there's a 263 situation. In fact, 263, the CIT sends it to the AO.
Yes.
If his rule of institutional bias is right, then the minute that 263 CIT opens, it's a meaningless exercise. You can argue institutional bias. The superior officer has asked him to re-examine. The man will say, my boss has asked me to re-examine. That's the end of the matter.
But by then, demand would have been there. And after 30 days, your Lordship knows the consequences. Attachment, all that will follow.
No. I'm on the institutional bias point. Because of this Act being in force for 60 years now, officers also understand what is their function in these different roles.
Right.
So we have to trust. Same way in transfer pricing. Transfer pricing officer also is an income tax officer only.
Right.
And then 3 of them sit in that appellate kind of a body at that next level, the CIT level. So they're all officers within institutions. Suppose they say our officers have decided How can we overrule our own officers? Suppose two of us decide as a writ appeal division bench, we say our own judge has passed, the single judge. How can we overrule him? We don't say that.
Yes. Correct. May I please 82? One paragraph.
Yes.
Only one, then I will close. Last page of the judgment.
Yes.
Similarly, in this petition, the order dated so and so passed by transfer paying officer has been impugned. The petition was stated by impugned order of transfer paying officer has made on adjustment enhancement of income so and so. Petition given is that after issuance occurs, even though it furnished replies dated so and so and dated so and so, wherein request was made to transfer paying officer to provide the material evidence relied upon by transfer paying officer for proposed adjustment in the so-called notice, they did not respond to the same. Instead, it has proceeded to pass the impugned order. These affirmations are not rebutted. We find that a fair procedure required the transfer pricing officer to supply the material based on which he proposed to make adjustment indicated so-called notice. The failure to do so, in our view, has vitiated the order so and so passed by the transfer officer. We accordingly quash the order. The transfer officer will, however, commence the proceeding from the stage at which he has issued the so-called notice. It relegated again back to the same stage. That is what I humbly say, that it didn't quash, but said that you go there and so that you will be given opportunity and all documents which are prejudicial into that will be supplied, and you can give a reply that will consider. Because once before parting with Millards, your lordship in the case in hand, which you are dealing with now, has put question on 4/5/2022, paragraph 2. Law and counsel for the parties require more time to examine the neat legal question that arises for consideration, whether for the purpose of section 148A of the Income Tax Act 1961, an actual physical hearing is envisaged in terms of section 148A. B, or a so-called notice and a reply thereto will satisfy the requirement of that provision. This is what your lordship wanted to address, Millards. And the question which was involved in Anshul Jain, Millards, I am just reading the question involved in that case, whether the issue is whether at this stage of notice under section 148, RIT court should venture into the merits when AO is yet to frame assessment or reassessment in discharge of statutory duty casted upon him under section 147. So, Millards, your lordship only is on the issue of whether hearing, physical hearing, or Millards based on reply to so-called will suffice under the scope of 148A. But that was not the issue there, which has been dealt on the apex court. So therefore, my whole endeavor for lordship is the judgment of the order of passed by the Honorable Supreme Court. In that case, doesn't Millards deter in any manner to your lordship to independently decide the case in hand, Millards. And again, Millards, one more thing, lastly, Millards, apart from that, what your lordship wanted me to address, the way, Millards, my only limited grievance for lordship is, Millards, I have diligently responded to the notice, Millards, on time, not beyond time. 15th March, on 15th March, I uploaded the time petition. It's a matter of record for lordship. I have
no, that's not the response. Your actual reply was sent beyond the date given to you in the notice to you. You had filed a time petition. They had not passed an order on the time petition. So you, without extension of the time expired whenever, 22nd March or some date it expired, correct? You were to file a reply by 22nd.
15th March.
15th March. I was
15th March, and on 15th March you filed a time petition. So you did not file a reply by 15th March. You filed a reply only on 23rd March.
That's only I will take my lord's attention. That's when there is an adjournment application. I leave it to lordship pillars. It's a statutory compliance. Whenever a statutory compliance is made and request for adjournment made, Millards, that's within the purview of the powers and obligations available statute, Millards. Is it not part of the assessing officer to respond to the request, Millards, either to grant or reject, Millards? And in that event, whether lying over my adjournment application and not entertaining the reply which I have filed prior to the date of passing of the order will at all affect.
Correct. Let them answer it. You're right.
That is my humble submission.
That's
and I will be happy.
Answer. Yeah.
So without going into all that, if lordship permit me, I am ready to participate in the proceeding where at that stage where I am agreed to. But in the manner that is my humble submission.
Correct. All right.
Obliged. Much obliged.
All right. So Sir, I want to start afresh. 4:10.
Yes, it's very dangerous.
I'm told the Bali Jatra has been extended by 1 day.
One day. Today, I was informed that Mr. Chimaka took a AC bus and has detoured.
Without giving you a cup of tea.
Without giving. And he said that you have missed it. I said that then it must be the Guinness Book of World Record that Mr. Chimaka has offered a pass. But that's in my case, I'll just do less. I know.
Because we'll have to continue only on Monday now. Tomorrow is not possible.
Not Monday, my lords. Can it be on Tuesday or Wednesday?
All right. Wednesday.
Wednesday. Much obliged. All right. It's a very good hearing, my lords. We are very thankful. We are thankful that
Wednesday at 2 p.m.
Justice judgment be returned, because I don't rely upon that justice judgment. I pray your response.
All right.
Wednesday at 2 p.m. Your Lordship may kindly say.
2 p.m. Interim order to